All right. So how many of you have been part of Level Up earlier? How many of you are just joined for this particular program? Okay, there are some students who are new also. All right. But I think you already attended a couple of classes. It has already started, or is there anyone who's coming today is the first day? All right. So I think on Thursday and Friday, you are having your science and technology. It's part of your GS paper 3. So I would be predominantly handling your GS paper 2. So your polity part, your governance part, your social justice part. So predominantly I'll be handling that, and the IR part maybe will be handled by Santosh sir. Okay, so that is how we will go about. So before I begin today's class, let me just briefly introduce about myself, and then I'll directly get into the subject. But before I get into the subject, I also wanted to brief you about this program and what is expected from the students when you write the mains examination. Anybody who has already given the mains in this class, who has got an experience of giving mains? So most of you are expecting to give the mains. This will be your first time if at all you are giving the mains. So there are few things that you may have to keep in your mind, which normally the students does not do, and they learn it by trial and error, and it takes some attempt to learn all those things. So probably you can avoid all those mistakes if you can keep these things in your mind. Okay, first let me introduce myself. I am Babu Gunashekaran. Gunashekaran is just my father's name. So we have a tradition of adding that in the end, or otherwise the name is Babuji. And I've been teaching this subject almost over a period of 8 years now. And before that, I've cleared this examination also. I've cleared this examination in CSE 13, in CSE 2016, in CSE 2017. But for some reason, I'm yet to join the service. So I have a lot of experience, not in terms of the student, but most importantly, I have been teaching this subject also. So over a period of time, based on the time that you spend, you also learn certain nuances, which is required to write good answers, and how to be very successful in this examination. So we'll also talk about those things whenever the time permits. But predominantly, the objective of this particular class is threefold. Okay, so what we are planning to do when it comes to GS paper 2, I'm sure that the other teachers will also have the similar approach, but maybe a little different also, maybe very little from subject to subject. So what is the prime thing that you are going to focus upon is, so this is a kind of a mains program, and we have got almost, say, let us assume 18 classes for polity, governance, and social justice, almost around 50 hours, let us assume, where we are going to cover, say, let us assume approximately, can anyone tell me what is the mains weightage for these three areas based on your observation? Polity, governance, and social justice. Almost 200 marks, yes, you are right. Almost it is 200 marks, where UPSC has been consistently asking for 50 marks from the IR part. But can you say the subdivision between these things? At least for polity, how much marks? And for governance and social justice, what is the weightage? 80, 85, 90? 90, 130. No, overall it is only 200, not more than 200 for all the three parts. So you are saying that it is 80, 90 there and the rest of the marks from the polity part. Okay. So I've gone through the extreme analysis of the polity. So what I have seen this in GS paper 2 based on the last 10 years of how UPSC is asking. If you say polity, where they ask 10 to 11 questions, in terms of questions, first I'm putting it across. And when you convert them in terms of marks, that is coming to roughly somewhere between 110 to 125 marks. There were years that up to 125 marks, there were years up to 110 marks. So that is the weightage for the polity part. And then governance and social justice. Let me not separate them because there are certain years more questions from social justice. There were certain years more questions from governance. But if you put across overall, you can expect, say, let us assume 5 to 6 questions. That is what I would say. Or if I want to change that a little, I would say here it is 9 to 11 questions. Here I would say it is 6 to 7 questions. This is how UPSC is asking. And that sums up around 60 to 75 marks. So that means overall, how much marks you expect? It is not less than, I would say it is 175 to 200 marks, but mostly it is 200 marks. It is only depending upon where it is more, whether it is in polity or it is in governance and social justice. So this is the weightage that we are going to see. And most importantly, how UPSC is asking questions in the mains examination. UPSC is not going to ask you as you would prepare for your prelims. I think most of you should be aware of this. UPSC is not going to pick questions from, say, let us assume if you have read Lakshmikant, from there it is not going to come, but UPSC has given you a detailed syllabus and it has to be a topic based approach. So what we are going to do as a part of this particular program, 3 important things that we are going to focus upon. What are the deliverables? I'll just take a couple of minutes, then we'll get into the topic. The deliverable is first topic based coverage. Comprehensive. That means we'll touch upon every syllabus that is given in your GS paper 2. And how we are going to do that? It will include both the conventional areas plus relevant current affairs. I'm saying relevant current affairs. We cannot go for all the current affairs, but we'll try to do the relevant current affairs. And on top of that, wherever it is relevant, we'll also try to solve the relevant PYQs. So that will be the approach. So in this way, we'll go by every topic by topic, making sure that we are trying to address each and everything that is relevant for the examination. Second thing, the most important thing is answer writing. In fact, that is the most important thing. So we'll also make you write answers in the class. Today, probably if time permits, I'll make you write one question in the class itself. But from tomorrow, it will be a regular routine. Whatever we have discussed in the class, whenever you come at 5 o'clock, the first thing is you'll write 3 to 4 questions in the beginning, say around 30 to 45 minutes. Depending upon the marks and the number of questions, you'll write the answers. And then we'll start the class and we'll discuss about those questions briefly. So in this way, your answer writing is also going to be taken care of. That's the idea. All right, so this is how we are going to proceed. But before I proceed with that, please come. Before I proceed with that, what is the thing that you have to keep in your mind when you write the answers? I'll just take another couple of minutes, not more than that. It has been the practice and habit of all the students that they try to write whatever they know. So when you write the answers, it is not about whatever you know, it is about whatever is relevant to the question. So first you understand the question, break the question, try to write whatever is relevant to the question. And on top of that, when you write the answers, try to use the relevant examples, especially in GS paper 2, the relevant case laws will make your answers better. All right. So with that brief introduction, let me just quickly get into what is the topic that you are going to cover today. The first topic in your syllabus. Can you just tell me what is the first topic in your syllabus? Anyone? Historical underpinnings. So let me just briefly discuss what may be covered under this historical underpinnings. So what do you understand by this topic of historical underpinnings? Historical underpinnings and evolution. What is given in the syllabus? What does it mean? Anybody can tell me? Can anyone tell me what is this topic is all about? Historical underpinning is all that has happened before the commencement of the constitution. So what is historical underpinning? It is not only all about that has happened before the commencement of the constitution, especially after the Britishers started ruling India, and then gradually a lot of constitutional developments happened in our country. You might know that there are 2 eras of constitutional development. Most importantly, it is the crown rule, and before that there was a company rule also. Now, this topic is not a very important topic, but if you see, UPSC has asked one question in the last 10 years from this area also. So I'll briefly touch upon this area also from the point of view of mains perspective. We'll write a couple of answers if time permits, or definitely write one answer in this particular area, which will summarize any question that can be asked from this particular area. Okay, that is all about the historical underpinning, which basically will cover the major essential things as to what happened during the crown rule, and before that it was in the company rule. We'll touch upon that. Now, what is the next point in your syllabus? Features, then features, amendments, significant provisions. Okay, let me take features and significant provisions. So what are the features of the Indian Constitution and significant provisions in the Indian Constitution? Now, in the entire Constitution, which is a very bulky document, there are certain things which are very significant. There are certain features which are very essential. So can you name some of those things which you feel very significant part of our Constitution? Okay, federalism, I'm not denying the fact, but federalism or certain things, if you look into the entire syllabus, there are certain things which are covered, which is again explicitly mentioned. So excluding those things, if you talk of federalism, there's a specific topic in your syllabus which talks about the center-state relations and devolution of powers to the local bodies. I'm not denying the fact that federalism is not a significant feature, but we'll not touch upon those areas which is explicitly mentioned. But there are certain things which is not explicitly mentioned. Yes. Fundamental rights, it's fundamental rights, secularism, directive principles of state policy. Judiciary again will not include in this area because there's a separate specific topic of judiciary, executive, separation of powers. So primarily this area will take care of, say, the topics which is relevant to fundamental rights, topics related to, let us assume, the directive principles of state policy, what is relevant under directive principles of state policy from your mains perspective, and a lot of philosophical themes, say, example topics like preamble. So all these things will be covered here, and apart from that, there can be other significant provisions also. Say, for example, there was a latest development with regard to Article 370, and the Supreme Court has looked into it. That's a significant provision. So anything in the Constitution will be significant, but we'll not be able to touch upon everything. We'll see what has happened in the current affairs, what there is a possibility which can be asked in the examination. So all those things will be covered under this particular subheading. And then what is the next subheading? Basic structure. I'm sure that you all are quite aware of the concept of what is basic structure, but we'll see what kind of questions can be asked in the mains examination. And basic structure along with certain amendments also. If there's any significant amendment, probably we'll see if there's any possibility. So for example, one significant amendment that has happened is the 106th Constitutional Amendment Act, Women's Reservation Bill. So we'll try to analyze possibly if there's any question that can come from these areas. So in this way, we'll try to cover upon each and every topic. And when you talk of fundamental rights, a lot of themes under the fundamental rights, we'll touch upon those things also. So our approach would be basically theme-wise. Our approach is not, I'll take up just Article 19 and discuss about Article 19. That's a prelims approach. But whereas when it comes to mains, it is theme-wise, we are going to touch upon every topic. And in the same way, I have given some crisp points also, which anyways we are going to discuss also. But we'll also try to not only understand the content, but how to apply those content for specific questions. That is what is very important when it comes to mains examination. Because most of you has cleared the prelims, you will have a lot of content, there's no doubt in that. But how are you going to apply those content to the questions that has been asked? That is what we are also, in addition to the content, we are going to learn in this particular class. All right. Okay, now we'll first go to the first topic, but first topic is a little factual, so I'll come back to that a little later in the class. First, come to the philosophical areas. Again, UPSC is asking one question in the philosophical areas every year. The topic, I think it might be more relevant to you. The concept like constitutional morality, constitutionalism, and the topic has not been directly asked, something which is called as transformative constitution, but indirectly questions has come. So it is very important first to understand these philosophical areas. So first I wanted to touch upon a topic of what is called as transformative constitution. So for this year, I am thinking that these three areas may be very relevant. And they're all interrelated to one another. One is transformative constitution. Second thing is social and constitutional and social morality. And preamble is an evergreen topic. It's a conventional topic which can be asked at any point of time. These are the three philosophical areas within your first topic. So first I'll deal with the topic of what is called as transformative constitution. Transformative constitution. Can you give me that copy if there's an extra copy? Transformative constitution. Thank you. Transformative constitution. But before I get into this particular topic very quickly, can anyone tell me what is this idea of transformative constitution? See, whenever you have to write an answer, you should have a very simple definition, a very simple way of defining something. It may not be necessarily a bookish definition or a standard definition. If you remember something, that is well and good. But otherwise, you should be in a position to define yourself in a very lucid language. What do you understand by transformative constitution? Changes in the constitution according to the changes in the society. Does it mean amendment to the constitution? Yes. When you say changes in the constitution according to the changes in the society, is that the idea of transformative constitution? Yes. Then what is the difference between a constitutional amendment and transformative constitution? When you say that it is just an amendment to the constitution according to the changes in the society, I'm not denying the fact that the constitution can be amended under Article 368. But that is not exactly what is the idea of transformative constitution. What is a transformative constitution? Transformative constitution is a very simple idea that constitution as a document is transformative in nature. The constitution inherently has a potential to transform the lives of the people. That is the way that the constitution has been designed. That is basically what is transformative constitution. So how do you put it in a very simple way as to what is a transformative constitution? Transformative constitution is an idea that the constitution has a potential to transform the lives of the people. Do you agree with this point? Has the founding fathers devised or drafted the constitution in such a way that the constitution has a potential to transform the lives of the people? If you look into the words of the definition that I've given, Professor Upendra Bakshi, he has said that it is nothing but the constitution has a potential to fundamentally transform the way in which the society is organized. When I say that, he says that the constitution has the potential to transform the way the society is organized. Say, for example, before the commencement of the constitution, in his idea, there was a lot of injustice in the society. There was a lot of inequality in the society. Was the constitution drafted in such a way to address all these issues? Do you agree with my viewpoint? Has a potential, is there a potential in the constitution to transform all these things in the society? Whether it is really happening or not, is there a potential to transform the society? That is what is the idea of transformative constitution. It is not about just merely the constitutional amendment. So transformative constitution, first you have an idea that it is a potential that is there to transform the society, constitution as a document. Now we'll have to support your evidences. So constitution has the potential to transform the society. So the key word is the constitution has the potential to transform the society. That's the understanding you have. Okay, you understood it, but how would you substantiate your idea? Yes, the constitution has a potential to transform the society. How will you say that, yes, there is a potential to transform the society? Okay, so whenever you take up such things, you go for a broader thing rather than going for a specific example. You'll have to take a very broad examples. Say that, yes, the constitution has the potential to transform the society. Okay, I'll continue further. Before that, I wanted you to read that particular question. Read that question and you say how you approach this particular question. Read the first question that is given. Don't go through the notes. Go through the question. And tell me what do you understand as to what is expected in the question. Both the questions are almost similar in nature. You just read the first question. I'll just read out the first question to all of you. The Constitution of India is a transformative document designed for a progressive society. Do you agree with this? You can agree or disagree only when you understand the meaning of the question. But now you have understood as to what is, please come in. First, now you have understood as to what is, please put your mobiles in silent mode. So now you have understood that the Constitution of India is a transformative document, that the Constitution has a potential to transform the society. Do you agree? Yes. Explain your viewpoint with suitable illustrations. See, the first part of the question probably is looking forward for your understanding of what is transformative constitution. And when it asks, do you agree? You should theoretically explain that also. Okay, these are all by which I can say that yes, the Constitution is a transformative document. You cannot write, yes, I do agree with that. No, it has to be done in an indirect way. It is not a direct speech. You'll have to, with examples or with the theoretical concepts, you'll have to explain them. Yes, the Constitution is a transformative document. What is the second part of your question? Explain your viewpoint with suitable illustrations. That means this question specifically also demands that you will have to give relevant examples or case laws, or both examples and case laws. Otherwise also, I would say, even if it is not asked also, it is better to write. But in this question, it is specifically demanded. You will have to give it. Okay, now you tell me your idea without looking into your notes. I think some echo is coming. Is it from that side or is it from here? Try to put your mobiles in silent mode. Okay. So now you try to tell me, okay, the idea of transformative constitution is the constitution has a potential to transform the society. Now you tell me, how do you substantiate that idea? I don't want examples. We'll look into the examples a little later, but I only wanted you to give some examples as the constitution has a potential to transform the society. These are the, I would say these are the provisions in the constitution that I can say the constitution has a potential to transform the society. Go for broader example. Of abolition of untouchability is definitely there. So it has ensured equality in the society. But rather than that, give a broader example. Tell me. The first and foremost thing that you should talk about is the fundamental rights. Does the fundamental rights have the potential to transform the society? Does it ensure equality to millions of people who are not having equality before that? When I talk about equality, it includes everything. No discrimination under Article 15. It includes untouchability under Article 17. A lot of things are covered by the principle of what is called as equality. In general, what is fundamental rights? What about the citizenship? Now, before the commencement of the Constitution, there was no concept of citizenship. In fact, the commencement of the Constitution has entirely changed the legal relationship between the state and the subjects. Before that, they're all subjects, and after that, they're all called as citizens. Citizens who are empowered with the idea of universal adult suffrage, the voting rights, the political rights for them to ensure equality. So these are all some of the major points that you should address and say that, okay, by this, I can say that there is definitely what is called as the Constitution as a document has a potential to transform the life of the people. When I talk of fundamental rights, the fundamental rights, one of the objectives, it also prevents any form of oppression, arbitrary action by the state. You all know that. But the Constitution has provided not only a vertical application, but also a horizontal application when it comes to the fundamental rights. What does it mean? A broader application when it comes to horizontal application. Does anyone know what is the difference when I talk of horizontal or vertical application? What does it mean when I say that the fundamental rights can be applied horizontally? Vertically, definitely, and also in certain extent horizontally as well. What does it mean by vertical or horizontal application? That is in terms of reservation. I'm talking in terms of the entire fundamental rights, horizontal, vertical, and horizontal application. Okay, to put it in a very simple word, let us not make it very complex.
Horizontal is between the citizens and vertical is between state and citizen. No, sir, horizontal is women and children, 15 clause 3.
Okay. All right. So a lot of theories that is coming out. Everybody has their own theory. Yes. Very good. See, vertical application means the application of rights only against the state. That means the state cannot arbitrarily do anything against a citizen. It is only against one specific entity. So who shall not violate the rights of the people? State. The state shall not violate. Vertical means it is always vertical. One single pillar, let us assume. Horizontal means it covers everybody. So vertical application means vertical application is only against the state. So if you look into the fundamental rights is of the opinion most of the rights are enforceable against whom? The state, but not all the rights. There are certain rights which are also enforceable against the citizens as well. So it does have a horizontal application as well. It has a broader application as well. Thereby, it also helps in protecting the violation of rights of the people, not only by the state, but also by the private individuals. So that thereby it is also ensuring what? It is also transforming the lives of millions of people. So the horizontal application part has a very important implication in your answer. And most importantly, the Supreme Court in the recent past has expanding the scope of fundamental rights horizontally. In some of the judgments, it has said that Article 21 is also against private individuals. So it is expanding the scope of the application. So thereby the Constitution has a potential to transform the lives of the people. So this is just a theoretical part. And if you want to add point, I can also add the concept of judicial review. The judiciary as a guardian of the Constitution. They have the power to judicially review the actions of the legislature and the executive, thereby whatever is wrong, they can transform the lives of the people. Now, these are all the theoretical aspect, but when I come to the illustrations or the case laws, I have to cite specific case laws. Now, don't look into your notes that I have given. Anyways, that is there for your reference. Can you come out and say, without looking into the notes, even if it is coinciding, that is all right. Can you tell me some judgment which has the potential to transform the life of the people, or certain judgment which has followed the principle of the idea of transformative constitution? When I talk of transformative constitution, it is not just the idea of various values, but following those values and how it has transformed the life of the people. What is the consequence of that particular judgment? Has it really transformed the life of the people? Has it really ensured equality to those people who have been discriminated for a long time? Has it really ensured the dignity of certain individuals who have been not been able to exercise those dignity for a long period of time? Then you can say, yes, these are all examples of judgments given by the courts which has really transformed the life of the people. Can you give me some examples? Navdeep Singh Johar case. So what happened in the Navdeep Singh Johar case? So you don't have to explain the case. Right? Again, I am explaining you. When you write the answer, you just write it in one single line. And what is the crux of that particular judgment is more than sufficient. Suppose in case if you're not having the content, let us assume, then you can explain a particular judgment as a case study. Maybe you can write it for 4 or 5 lines. In the remaining areas, you just give the examples. That is more than sufficient. As what happened in Navdeep Singh Johar case? Decriminalization of section 376, but how it has transformed, that is the question. How section 377, decriminalization of section 377 has transformed the life of, say, let us assume certain sections of the people. Has it ensured equality to certain sections of the people by decriminalizing section 377? In fact, the Supreme Court in this said that the sexual orientation of every sections of the people has to be equally protected. So decriminalizing certain criminalizing certain sexual orientation is a classic violation of principle of what? Principle of equality. The constitution does not say for that. And if you have to transform the lives of these people, you have to abolish that. So that is what is about Navdeep Singh Johar case. Any other judgment? We have given a number of judgments. Sabrimala case, very good. Sabrimala case was also ensured equality to women who have not been allowed to enter into the temple in the age of 10 to 50 years. Very good example. So you don't have to write a lot of examples. Try to have at least couple of examples. But anyways, I've given 4 case studies and examples for each and everything. But you try to have at least, remember at least 2 when it comes to the examination. So if you look into your notes, I've given those examples. Sabrimala case. I've also talked about the Joseph Shine case. How many of you are aware of this particular Joseph Shine case? Which is about decriminalization of adultery. I'm sure that most of you are aware of the offense of adultery. So adultery has been now decriminalized. Can you tell me how it is related to transformative constitution? How it transforms the position of women? The women was considered to be just considered to be a property of men in one of the aspect which is going against the dignified life of a woman. And this law was also discriminating on the basis of sex. If you look into that law, although you don't have to remember the provisions of section 497, if you look into that particular law, while the husband can prosecute the man who is having sexual intercourse with the woman, but the wife cannot prosecute the husband if the husband is having sexual intercourse outside the marriage. The husband can be prosecuted probably if he is having sex with a married woman by the husband of that particular woman, but not by the wife. So it was a lot of discrimination which was there, which the Supreme Court said that again equality is important and women should not be considered to be a property of a man, which is a classic violation of a dignified life. Okay, so here again they have brought in the principle of gender justice and equality, transforming the life of women. Just one more example that I will add. In fact, this is a very important judgment, although not in the recent past. How many of you heard about this NALSA judgment in 2014? Right of the third gender, right of the third gender to identify themselves as the third genders. And does it transform the life of those people? By identifying themselves as a third gender, now they are able to make applications. Now it is allowing them to have equal access and opportunities when it comes to jobs and other areas. So that way it is also transforming their individuals. Now all these things has been rested upon, if not the other principles, one important principle is the equality. The Constitution relies upon equality, and this principle of equality is transforming the lives of the people. And then you agree, then does the constitution has a potential to transform the life of the people? Is a constitution a progressive document? Definitely yes. Okay, so this is what this question is all about. This question has already been indirectly asked, so they can again ask you. If you look into the philosophical areas, more or less the same questions are asked in multiple ways. Okay, so again read that particular question. What the question is asking: the Constitution of India is a transformative document designed for a progressive society. Do you agree with this viewpoint? How do you substantiate that? Now you have certain theoretical points, and then on top of that, it is saying explain your viewpoint with suitable illustrations. So do you have illustrations to explain your point? This question is similar to that of the second question. So please have a look into the second question. Okay, so before I conclude this particular thing, I'll just take up your question. So before I think, so you started the question, you explained what is transformative constitution, then you gave you explained some theoretical aspects, what is the provisions, how it can transform the life of the people. Then you also gave a lot of case studies or examples. Then how do you conclude this question? I'll take up your question, but before that, how can you conclude this particular question? When it comes, what is the way by which you think you can conclude this? So who has a very important role to play in transformative constitution? It is a judiciary. Ultimately, who is the guardian of the constitution? See, in introduction and conclusion, there are no specific guidelines per se. But most importantly, it should be related to the question. So that is where you will have to have your own innovative ideas. How do you introduce, how do you conclude? But it is related to the core idea, what is asked in the question. So definitely nobody can deny the fact that the judiciary has a very prominent role. We have seen the examples also. But I have been going through some of the articles. If you see, the judiciary has also gone through a number of phases in our country, the various judgments that they are given. There was a era in Indian judiciary where they were just relying on a textualist approach. What do you understand by textualist approach? Going by whatever is the literal meaning of the text in the constitution. They're not looking into the purpose behind these things. They're not looking into the entire objective of the constitution or the philosophy, but just going by the mere text and then interpreting and then giving the judgment. That's a textualist approach. So you can also summarize, if the constitution is to really act as a transformative constitution, what kind of view the judiciary has to take? They have to take a textualist approach or a purposive approach. A textualist approach is going by the words, but a purposive approach is not going by the words, but they are going by the objectives in the constitution. So similar, that's just one example that I'm giving, the way forward or the conclusion you can write for such questions. And if you want an example of that for a textualist approach or a purposive approach, how many of you heard about this A.K. Gopalan case? So this is one judgment which is said to be textualist in its approach. How many of you remember what is this A.K. Gopalan case? Although you don't have to explain this as a part of your conclusion, even if you write just textualist and the purposive approach, that is sufficient, but maybe you can use it in the other areas also. So how many of you know about this A.K. Gopalan case? Why it is called as a textualist approach? What was held in this case? The crux of the case. We are not going to the detail of the case. No, it is not about amending the fundamental rights. In A.K. Gopalan case, it was all about the interpretation of Article 21. A.K. Gopalan was taken into preventive detention. He challenged this preventive detention to be violative of his various fundamental rights, including his right to life and liberty. And he also argued in this case, Article 21 is related to the other fundamental rights. And the fundamental rights are not watertight compartments. They have relation to one another, which the Supreme Court has not agreed. The Supreme Court said that each and every fundamental right is different. And most importantly, they emphasized on the fact of procedure established by law, because they said that individual can be detained. The only limitation upon the detention is they should follow the procedure established by law. Without following the procedure, they cannot detain you. They are strictly restricted to the text in the constitution. But whereas later that was changed by the Supreme Court in the Mena Gandhi case. In Mena Gandhi case, what is the approach they have taken? In Menaka Gandhi case, they said although the text in the constitution is due process of law, it has to have the same meaning as that of due process of law. So in Menaka Gandhi case, the approach they have taken is not textualist approach, but they have taken a purposive approach. So such things can be used as a very good conclusion, which can help you in adding a lot of marks to your answer. Okay. So what is the difference when I talk about the procedure established by law and the due process of law? Because we'll also come to Article 21. It requires this discussion also. So because I've taken it, can anyone tell me in one single line what difference does it make? Yes. Yes. But PIL and writs are just a tool. You bring it to the notice of the Supreme Court. But predominantly, when you talk of transformative constitution, try to take some provisions in the constitution. Try to take some provisions in the constitution. That would be a better approach to this. Although you can add, because it is the Supreme Court which has now constitutionalized all these things, the PIL and all those things, which is again the part of, I would say, the larger power of the judiciary, the power of the judiciary to judicially review. But rather you take some concrete provisions in the constitution, that would be a better approach. Yes, what is the crux of difference between A.K. Gopalan and Menaka Gandhi case? That is, what is the crux of the difference between procedure established by law and due process of law? Very good. Very good. In crux, in nutshell, this is the thing. So the procedure established by law is providing protection only against arbitrary executive action, not against arbitrary law. Law can be arbitrary, but if provides for a procedure and that is followed, then no remedy. But due process of law is providing protection against, not only against arbitrary executive action, but also arbitrary legislative action. So anyways, I'll come back to this area. So this is the same thing that you can apply. If not everything, at least 2-3 points in theories, 1 or 2 case laws, a good introduction, a good conclusion will get you 50 to 60% of the marks in such question. Okay. Now the most important thing that you have to break when you write the answer is, okay, for this particular question, you have seen an approach. The content is going to be the same, but you will not follow the same pattern or the same structure to all the question, even if it is going to be from the same theme. So try to understand the question and accordingly apply your knowledge. Then only you will get the maximum marks. But almost the second question that I given is also on the same pattern. Just look into that question for a moment, and then we'll move forward. So we'll also solve some questions like this here. And then when you come tomorrow, if you have, let us assume, seen 10 questions in today's class, I'll give you 3-4 questions from these areas, and you also have to write answers. Because just listening and just doing this exercise may help you to have the points, but how do you put it across is also very important. Okay, so we'll do that exercise tomorrow when you come, but just go through the second question. Is what is your doubt? What kind of criticism? Okay, so there can be constructive criticism, but you'll have to see that public order is given in which context. You cannot just stand alone, or you cannot just take public order. So public order is usually a form of restriction upon the fundamental rights, as far as I understand when you bring in this. But the very concept of right itself is not absolute. So the rights can be restricted. But I would say that rather than criticizing the provisions in the constitution, rather you can say that the way it is implemented is very important. So you'll have to be very diplomatic, but again, it is up to you to go for the criticism. But this question, I don't see per se there can be a criticism to this. But again, these are all merely speculations, the way that you write answers, you can have your own answers. But this question, I don't see any criticism per se, but if you want to write, you can write it. That is not an issue. All right. So please have a look into the question number 2. The Constitution of India was not just a founding document. It had a radically transformative vision. So what is your understanding? So here it is just saying comment. So what does it mean by comment? What does it mean by comment? So the earlier question is saying that do you agree, and it is asking, saying that explain your viewpoint with some illustrations, but here is just given the word comment. So what is your understanding of the word comment? Anybody? Comment means you just write. You write whatever you understand about that particular topic. So you comment about it, and ultimately in that particular question, you have your own opinion also, which will anyways reflect in your answer. So here also, anyways, whether it is asked or not, the case laws examples, if you give, you write it. That will fetch you the better marks. Okay. So anyways, tomorrow we'll write an answer in any of these questions. Now come to the next topic, that is constitutional or social morality. Any questions in this particular topic? Have you understood the crux of this particular topic? What is transformative constitution? Transformative constitution is not just amendment to the constitution. What is transformative constitution? As a document, the constitution has a potential to transform the society by the various provisions in the constitution. That's basically the idea of transformative constitution. It's better that you give an example from the recent past. Although I'm not restricting only to the recent past, but it is better. Any other questions? All right, so come to the next topic, that is constitutional and social morality. But before going to that particular topic of constitutional or social morality, just go through the question that I have already given. See, certain type of questions, I may not give you notes, say for example, preamble, but we'll discuss that in the form of the questions. So certain areas I'll give you questions, make you write the answers, and during the discussion of the answers, I'll discuss that. Okay. But I know that certain areas you may not have the content, that I'll give it as a content and we'll discuss that also. And certain case laws can overlap. It can be an example of the idea of transformative constitution also. It can be part of constitutional morality also. It does not matter because not both the questions are going to come. You can use the case laws accordingly as relevant in the question. Okay, look into the first question there. And can anyone tell me what do you understand? How would you, what do you understand by this particular question? Constitutional morality, even if there is tension with existing social morality, should not be rejected. In fact, this is a statement that was given by Chief Justice of India, the present Chief Justice of India, D.Y. Chandrachud. So he said that the constitutional morality, even if it is in conflict with the social morality, you should not reject the constitutional morality. So to write this answer, you should have an understanding of what is constitutional morality and what is social morality. So without having the idea of these things, you cannot write the answer. So who can tell me what do you understand by the idea of constitutional morality? What is your understanding of this topic? Constitutional morality or the social morality, anything, whatever you understand. Respecting the provisions of the constitution. Who said that? Respecting the provisions of the constitution. Can you further elaborate? What do you mean by respecting the provisions of the constitution? You mean to say adherence to the principles or the values laid down in the constitution? Adherence to the values by every institution in our country, by the individuals in our country, and if their actions are strictly in line with the values which is prescribed, can you call that to be a constitutional morality? Yes, that is basically what is constitutional morality. To put it in a very simple word, what is constitutional morality? In a democratic setup, each and every institution, for that particular matter, it can be any institution, their actions has to be in line with what? The values that is prescribed in the constitution. Okay, so that is what is the idea of constitutional morality. Then what is the social morality? Yes, social morality. Very good. So there are certain actions or behaviors which as an institution they may approve or which as an individual they may approve, but it is backed by the social practices. Or in other words, I can say there are something which may be considered to be ethical but may be illegal. So if I say there may be ethical but it is illegal, but still it has been practiced. It is practiced in our country despite the fact it is illegal because it has a social sanction, it has a social approval in our country. And those kind of actions may be called based on the principle of what is called a social morality. So now this question is trying to assess your understanding if there's any conflict between the idea of social morality and the constitutional morality, which is likely to prevail. The idea of constitutional morality should prevail. Whatever is there in the constitution is supreme. That is what this question is trying to assess. And we have certain examples also for the idea of what is social morality and some judgments also. But can you give me some examples which may be ethical, but it is illegal, which may be practiced. Ka Panchayat, which I have anyways given that example in the notes. If you see the Ka Panchayat, it is still practiced in some parts of the country where the society does accept, but is it legal? Will the courts accept that? Does the constitution accept that? The constitution does not accept that. What about live-in relationship? What is the status of live-in relationship in our country? Does the constitution accept the live-in relationship? In fact, after this right to privacy and even before that, right to privacy, can anyone tell me in one line what does it mean by right to privacy? Right to privacy has a lot of dimensions today, but if you have to look into this right to privacy, the state has no business interfering the personal affairs of an individual. With whom one is living, whether he is married or unmarried, it is not the business of the state. So in fact, today the live-in relationship is very much legally valid. But does the society accept the live-in relationship in total? So if the court is to see this particular matter of live-in relationship, what is the stand they have already taken? And if they apply the principle of constitutional morality, what is the stand they are likely to take? Is that they will legalize this live-in relationship. Okay. So that is the idea of what is called as social morality and constitutional morality. And there's a question that was asked in UPSC that the idea of social morality is very much rooted in the constitution itself. There are certain values which has to be definitely followed. Can you say some of the values which are very much deeply rooted in the constitution? The most important values in your opinion? Look into the preamble. The preamble is something which summarizes what are the various objectives or various values in the preamble. The ideas of equality, justice, liberty, fraternity. These are all values which cannot be ignored. I think a couple of years or 2-3 years back, there was a question. The idea of constitutional morality is rooted in the constitution itself. That means these are the values which are rooted in the constitution, which the court cannot deny. Even, or not just the court, even the other institutions in a democratic setup, they cannot deny, even if it is in violation with the social practices or the social morality. That is what is the understanding. So in the recent past, can you tell me some of the judgments which has been taken with the idea of what is called a social morality? Again, Sabrimala temple case, because there is a popular support with regard to Sabrimala temple case that women should not be allowed to enter into the temple. That's a social values and norms. But what did the Supreme Court say? The Supreme Court has applied the constitutional morality. What about decriminalization of section 377? Was that also socially accepted? That the predominant view of the society is that LGBT sex should not be decriminalized. But then the court has gone against it because they applied the principle of what? Social morality. But I'll give a different dimension of example. How many of you are aware of this the Government of National Capital Territory of Delhi case? The case that I have given in the example, NCT Delhi case 2018. In this case also, the Supreme Court applied the principle of what is, which may also be related to the idea of federalism, but here I'll take it, NCT Delhi 2018 case. So here also the Supreme Court applied the principle of what is called as constitutional morality. What is this case all about? What is the crux of this case? Can anyone tell me? That was related to service cases that came after this. Even before that, there was a dispute between LGT, the Lieutenant Governor, and the elected government of Delhi, specifically because of this particular provision, Article 239 EAA Class 4. Does anyone know what this provision provides for? This was a crux of issue between the Lieutenant Governor and the elected government in Delhi. What is this provision in the Constitution? Can anyone recollect? This was a crux of the dispute. Everybody will agree that the Delhi has a special status despite being a union territory. That special status is given by virtue of Article 239 AA. But if you go to a specific subclass under this, Article 239 AA Class 4 says that in case of any disagreement between the elected government and the Lieutenant Governor, the Lieutenant Governor can refer the matter to the President and act according to the direction that is given by the President. But the Constitution does not say in which matter he can refer. If there is any difference of opinion, he can refer. So that means the Lieutenant Governor can have differences of opinion in any matter. That means if the LG is having difference of opinion in all the matter, then you are just reducing elected government without any powers. Ultimately, it will be done on the advice of the directions of the president. That means you are reducing an elected government. So when this matter has gone, the interpretation of this matter has gone to the Supreme Court. The Supreme Court categorically said that the LG should not act as a constitutional obstructionist. Although it is not defined anywhere in which matter you will do it, but you should not act as a constitutional obstructionist. Rather, you should follow the principles of constitutional morality. And what are the values in the Constitution? The elected government should advise you, and as per the advice, you should function. So as this constitution has entrusted some faith upon the office of the governor, do not act as a constitutional obstructionist, rather follow the principles of constitutional morality. So in a parliamentary democracy, the idea of constitutional morality is you follow the advice which is given by the Council of Ministers. So in that sense also, they use the word constitutional morality. So basically, what does it mean by constitutional morality? That actions of any individual, or for that matter, any institutions in a democratic setup, their action should be backed by what? Or their action should be in line with the values in the Constitution. Some of the important values when you take to individuals: equality, justice, liberty. When it comes to an office of the governor, to abide by the aid and advice of the Council of Ministers. But in the same judgment, the Supreme Court said, if there is a substantial differences of opinion, you refer the matter to the president, no issues. But not you will refer each and every single matter to the president and you act as a constitutional obstructionist, and then you are not following the principle of constitutional morality. So you can have diverse examples also when you write the answers. So on the contrary, what is social morality? What is this idea of social morality on the contrary? The actions are backed by the values and the norms in the society. There can be a number of general examples that I can give, but recently there was a case in Uttar Pradesh that I was going through some article, and then I found that it was very unfortunate that a high court has followed the principle of social morality in giving its judgments. And the name of that particular case is, I just pointed out there, you can see that there's a case which is called as Kiran Rawat versus State of Uttar Pradesh case. Uttarakhand or Uttar Pradesh? It was Uttar Pradesh in the newspaper. I'm not sure whether it is Uttar Pradesh or Uttarakhand, but as per the newspaper report, it is Uttar Pradesh. Now, this case is all about an inter-religious couple who are in a live-in relationship, and they were harassed by the police because of the complaint filed by their parents. A Muslim man and a Hindu woman, they were in a live-in relationship, and there was police harassment because of complaints filed by their parents. And then subsequently, they have gone to the protection of the High Court to have protection from the police harassment, which the High Court has not given them any protection. In fact, the High Court has given an opinion in this particular matter in such a way that they are not approving what is called as a live-in relationship, which already the Supreme Court of India has accepted. So this kind of judgment which is given by a court is reflecting the idea of what? It is reflecting the idea of social morality. It is not reflecting the idea of constitutional morality. Okay. So try to have examples that will help you in writing the answers. Okay. So this is what you'll have to understand by the idea of social morality and constitutional morality. And how do you relate this Justice Puttaswamy case in social morality? Sorry, constitutional morality. What is Justice Puttaswamy case is all about? Right to privacy. This was the first time the Supreme Court has declared that the right to privacy is implied under Article 21 of the Constitution. And how they are relating this right to privacy, this particular judgment is related to the idea of constitutional morality, because they said that any individual to exercise their dignity, they should need to have privacy. So the primary idea is that they relied upon the dignity of each and every individual, because they said that without dignity, without privacy, the dignity cannot exist. So the very idea of saying right to privacy to be a fundamental right is they recognize the idea of what is having a dignified life, which is part of right to life. And thereby, again, it is rooted to what is called as the constitutional values. Okay. So in this way, if you want, you can relate most of these judgments, but have one or two examples. That is more than sufficient when you write the answers. Come to the question number 2 in the same thing, that is in the constitutional versus social morality. Constitutional morality is rooted in the Constitution itself and is founded on its essential facets. That's the statement. Explain the doctrine of constitutional morality with the help of relevant judicial decisions. Take 2 minutes. Just Give me the structure. I want just the structure, not the answers. You don't have to write an answer. I just want you to write the structure for this particular question. Because ultimately, after having the content, this is the most important exercise that you do. Write and see how you are able to present your content. And once you write the structure, please write it and then. And whenever you write an answer, it is not essential that you'll always have a critic. Wherever there's a scope for criticism, you can do that. Okay, I'm not saying you should not do it. Wherever there's a scope, you can do it. But let the criticism be a very constructive criticism. Just don't criticize. Whenever you criticize, try to give some kind of ways to overcome that as a part of your way forward. See, when it comes to polity paper, these keywords are very, very important to fetch more marks. Say, for example, I use the word constitutional obstructionist and constitutional morality or social morality, transformative constitution, constitutionalism. Whether the question is directly asked or not, you try to use these words in your answers to fetch better marks and try to have some case laws to get better marks. Okay. Constitutional morality and constitutionalism. If you say constitutionalism is almost similar to that of the constitutional morality, because constitutionalism also says that adherence to the values in the constitution. That's a very plain way of saying that. But the constitutional morality has been recently used in the Supreme Court and all those things, so it became very popular. But I don't see any meaning in terms of when you use constitutionalism and constitutional morality. So if there's a question that is coming in the constitution, so this constitutional morality, I'll say if you have to find some difference, this constitutional morality is always used in the context of social morality. Otherwise, you can just use the word constitutionalism. That's the only difference. Okay, anyone who can volunteer as to what is the structure for this particular question? First, tell me what do you understand in this particular question? Constitutional morality is deeply rooted in the constitution itself and founded on its essential facets. Very good. One way of interpreting that is yes, that there are certain important features which cannot be ignored, which is very well there in the constitution. Okay, while writing an answer, what is the structure you will follow in this particular question? Anybody wanted to yes? Okay. What are the provisions that you will write very quickly? Some provisions.
Like pride or resistance.
Oh, okay. Only one provision you have written, or you have given many? At least try to give 2 to 3 provisions, which reflects the idea of the constitutional morality, and these are very essence in the constitution. And then, very good. Always try to bring in the aspect of judiciary. Whether it is asked explicitly or not, you give some theoretical aspects what is there in the constitution, and then also bring in 1 or 2 aspects of the judiciary so that you can bring in some case laws. Very good. Yes, you can use it. If you can remember, you can very well use it. But remembering things, that is not an easy thing unless until you are already prepared. But you should use such things. If you can remember, it is definitely going to add value, but do not write as if you are saying that. You always put that this was said by Chief Justice D.Y. Chandrachud. That could add value to your answer. Okay. All right, so come to the next part of the, tomorrow we'll do some writing exercise. Come to the next thing, that is the fundamental rights. We'll try to cover the fundamental rights. And then in the end of the class, I'll take up the topic of historical underpinning, because that's a very factual thing. Come to the fundamental rights. Again, what are the major themes in the fundamental rights? For this particular question, I'll just see the question. Explain the doctrine of constitutional morality with the help of relevant judicial decisions. Okay, so you just explained, you defined probably the constitutional morality, you gave some theoretical points, and then you gave some judicial judgments, and then finally you can come and say it's really important that the judiciary as an important pillar in the constitution should always give importance to the constitutional morality, even if there is a conflict with social morality. Because certain instances, the judiciary itself has taken the idea of social morality. That is one way of concluding it. I'm just saying one way of concluding it. So because whenever they use the word constitutional morality, they wanted you to understand the difference between constitutional and social morality. So as an institution in a democracy, or the judiciary for that particular matter, whenever there's a conflict, which should be given primacy, it is the constitutional morality. That is one way. It can be multiple ways it can be concluded. Okay. So even if the question is explicitly asking only about the constitutional morality, you yourself bring in the concept of social morality and try to give priority to the constitutional morality. Okay. So come to the next topic, that is the fundamental rights. Okay, so there is one more thing that is to be added to that transformative constitution, constitutional social morality. One more thing is, suppose if there is a question on constitutionalism, you can use the same thing, but there is no need to refer to the social morality in that case. Same examples can be used. Hmm. Hmm. Which? Hmm. Hmm. You're talking about the second question? Hmm. Hmm. No, once you explain, then you don't have to explain. Yes. See, in a question, there can be certain areas of overlapping. So once you're already defined what is constitutional morality, you don't have to again go and define that. You more explain that particular doctrine. What does it mean with examples and all those things? See, whenever you take up a question, not necessarily you'll have to follow the same structure as it is asked in the question. The only thing that you have to make sure is that you'll have to address each and every part that is asked in the question. You can have your own structure. So not necessarily in the same order. Suppose if you have started with the definition, then you just explain it to the examples. That is more than sufficient. Come to the next thing, that is the fundamental rights. Okay, in the fundamental rights, I would see that these are the important themes, because UPSC usually asks different types of questions. I have analyzed the 10 years of question, how they are asking. They're asking conventional questions, but not much, but yes, they've asked conventional question. So for example, I think a year back or 2 years back, there was a question on the right to freedom of movement and residence. There is right to freedom of movement and residence, but although not an absolute right. It's a direct question, conventional question. They can ask you still conventional question. But we don't have the time to go into each and every conventional area. I leave it mostly to the students, the conventional topics to deal with. But we'll also touch upon the important areas, but not all the things. Second type of question is conventional plus certain current affairs. And then purely current affairs. For example, there was a question on right to privacy. What do you understand by right to privacy? What are the different dimensions of right to privacy? In 2017, there was a Supreme Court judgment on right to privacy. In 2018 mains paper, there was a question, what do you understand by right to privacy? What are the various dimensions of right to privacy? But most importantly, they're asking themes. They're asking the themes based question, especially from Article 21. So we'll go with article by article. if I say theme-based question, Article 21, which talks about right to life and liberty, one theme could be how right to life and liberty or the interpretation of Article 21 has resulted in better gender justice. That means when I say that Article 21 and gender justice, that all those judgments which is given by the courts, which has improved upon the life of women, brought them equality. So you should have 4 or 5 judgments. UPSC has already asked this particular question, that Article 21 and how it has brought in the environmental rights. So environment and Article 21 is one specific theme. So UPSC is now especially focusing upon such themes as well. So we'll also address the theme-based questions. Okay, so these are all the different things that will go on. So when you talk of fundamental rights, for me, the first thing as we'll start is, the first thing is the right to equality. That is from Article 14 to Article 19. Sorry, Article 14 to Article 18. Right to equality. And in right to equality, there can be different types of questions that can be asked. But before I get into this theme of right to equality, there can be a very conventional question from Article 14 itself. Sometimes I can ask you conventional questions. Article 14 talks about equality before law and equal protection of law. Now, who can tell me what is the difference between this equality before law? Oh, Mukesh is there. I did not notice Mukesh. Okay, so what is the difference between equality before law and equal protection of law? So who can differentiate this? The very first article, because then only you will be able to subsequently understand and observe whatever I discuss. What is equality before law and equal protection of law? Equality, if you look into the constitution itself, it is saying equality before law and equal protection of laws. One is in singular and other is in plural. So what do you mean by equality before law and equal protection of laws? Very good. See, the equality before law is not talking about any law that is made by the legislature. Equality before law is just an idea. What is this idea, equality before law? This idea is saying, it's an idea, it's a theory, it's a philosophy, it's an idea that everybody should be treated equally. Or in other words, there is a supremacy of law. Nobody is above the law. That's an idea that we should follow in making the laws. That whenever the legislature makes the law, the second part, when I talk of the equal protection of laws, it is the law made by the legislatures, the ordinary laws. The first part is not about the ordinary laws. The first part is an idea. But this idea should be respected in the second part. What is the second part is saying? That the ordinary laws which is made by the parliament or by the state legislature, that should respect the first idea. And it is talking about what is called as equal protection of laws. But the second part is saying whenever the law is made by the parliament or by the state legislature, that they have to respect the first part. That means that the law should treat everybody equally. But it doesn't mean that in all the circumstances. Because in a country like India, not everybody is equally placed. Not everybody is equally placed. So there are a lot of differences in our country in terms of historical deprivations, injustice, inequality. So the second part is saying that while the laws are made, it should treat everybody equally only when they are equally placed. If they are not equally placed, then there can be discrimination. So it doesn't mean that there is no discrimination. Discrimination per se is not a wrong thing. But what is not accepted under the constitution is that there should not be arbitrary discrimination. When I say arbitrary discrimination, then what type of discrimination is allowed under the constitution? Is there any form of discrimination allowed under the constitution? Does Article 14 recognizes any form of discrimination? I'm exactly looking for that word. What kind of discrimination? Positive discrimination or an affirmative action. It allows for what is called as positive discrimination or an affirmative action. So only when you understand this, you will be able to approach questions from Article 14. Otherwise, you will not have the proper conceptual understanding. So can you give me an example of positive discrimination or affirmative action? Example is reservation. Very good. Reservation is one such example. Okay, subsidy. Today, if you see that free bus ride is given to women, free ride is given to women in metros. These are all based on the ideas of positive discrimination, because men and women are considered to be two different groups. They're not equals. That is what is the principle behind this. How do you define positive discrimination? If you have anyone to define positive discrimination or an affirmative action. In fact, positive discrimination is a form of an affirmative action. What is a positive discrimination? No, you are explaining that, but if you have to define that in the examination, because you need to have a small definition to write all those things. That's why I'm making this practice. Hey, discrimination on the basis of caste is a positive discrimination. Discrimination? No, positive discrimination can be on the basis of caste also. Reservation is basis of what? Reservation is predominantly on the basis of caste. There can be other factors also, but predominantly on the basis of caste. That's a positive discrimination. So what is discrimination? Positive discrimination is discrimination in favor of, say, the vulnerable, in favor of the disadvantaged, in favor of the backward classes. And right now, the economic aspect has also been added. The economic weakness has also been part of the affirmative actions. So whenever you talk of an affirmative action or a positive discrimination, that is discrimination in favor of these sections of the people who are not equally placed with the forward class or the advantaged class. So these are all considered to be positive discrimination. Of course, it's based on the principle of justice. That is what is social justice. These are all examples of what? Social justice. Yeah, you can say it is similar to that of the word equity. So when you talk of these things, there's a difference between the word equality and justice. When I say justice here, it is not the judgment which is given by a court of law. I'm more relating to the concept of social justice. So social justice is not about equal treatment. Social justice is about treating people who are equally placed equally. It is not about not treating everybody equally. Okay, so that's the idea. It is more relevant to the concept of equity. Yes, you can put that. No doubt. Now, as we'll proceed further, first you will have to have an idea of what is positive discrimination, what is affirmative action. Then only you will be able to approach any questions. Otherwise, you will not be very clear. Now, the important theme for me under the right to equality is this reservation. You should know the things about reservation, because reservation is an example of what? Reservation is an example of positive discrimination or an affirmative action. And one recent update that has happened with regard to reservation is also the EWS reservation. I think UPSC has not asked any mains question from the EWS reservation. So you should also understand that how this EWS reservation, and then I think few years back, I think 1 or 2 years back, there was a judgment also on EWS reservation, where the constitutional recognition has been given to the EWS reservation. So I'll just quickly go through the reservation, and there can be a question on the gender justice also. That is another thing. These are the two important themes in my opinion. Gender justice. Is there any judgment in the recent past that has ensured gender justice, ensuring the equality of equality of the women? We have just seen few examples. Adultery is one example, very good. Shabarimala case, you can use it. And is there any other judgment of the Supreme Court? Entry of women in the armed forces, permanent commission of women in the armed forces, that's an example. How many of you are aware of that recently the Supreme Court has also given judgment that there's complete bodily integrity and decisional autonomy of a woman to medically terminate the pregnancy. So that is, again, she can decide that. These are all some judgments where it is trying to ensure equality and gender justice to women. And you can add any cases that you know related to the concept of the Uniform Civil Code also. So try to use your comprehensive knowledge. But anyways, I'll touch upon all those things. So these are the two broad things for me that may come from this particular topic. How Article 14 or the principle of equality has been applied to ensure gender justice, or how reservation has been in our country. So both areas the questions can come. So first we'll see the reservation, then I'll move forward. So come to the topic of reservation. Okay, so just go through the question before I discuss the reservation. Then I'll give content for this particular, explain the content. Go through the question. Can anyone tell me what do you understand by this question? Can reservation be used as an instrument of affirmative action to address economic weakness? What about this particular statement? Justify your views with relevant reasons. When I say justify your answers with relevant reasons, because there's a judgment, you'll have to quote the judgment. If not the judgment, at least the reason that is given by the judgment. Okay, can reservation be used as an instrument of affirmative action to address economic weakness? Is it possible? Is the state using economic weakness to provide some affirmative action? And what is that? EWS reservation. So the question is asking about the EWS reservation. Indirectly, it's only pointing towards the EWS reservation. But you should also justify as to how this EWS reservation was upheld by the Supreme Court. Does anyone know what was the justification that was given and what was the challenge to this EWS reservation? What was the challenge to this EWS reservation? Okay, so that is a point, but what is the major criteria? Yes, you are right. Okay, one is in the Indira Sahni case. I think most of you might be aware of this. In the Indira Sahni case, they said that reservation should not be over and above the principle of 50%, including the other backward caste, scheduled caste, and the scheduled tribe. And anything above 50% would violate the principle of equality, or it would violate the principle of rule of law, which has been declared to be the part of basic structure. So one element of challenge was that it is breaching the 50% limit, so thereby it is violating the basic structure. Okay, agreed. But there is another issues that was also, there were other issues that were also raised. Very good. Whether economic criteria can be the sole criteria based on which reservation can be given. Because what has been guaranteed in the original constitution and continued before the EWS reservation in 2018, that is the 103rd Constitutional Amendment Act. So before this 103rd Constitutional Amendment Act in 2018, what was the reservation or what was the basis of approving reservation? The only criteria was the social and educational backwardness. So before that, what was the criteria? Social and educational backwardness. Okay, I'll complete this EWS, and then if you want me to go through the entire reservation, if it is required, I'll go through. Otherwise, first I'll complete this EWS reservation. So the predominant the criteria based on which the reservation was given is in social and educational backwardness. In social and educational backwardness, do you know what is the predominant criteria? The caste. Caste is the predominant criteria. The Supreme Court, although has said that caste should not be the sole basis, but caste can be the predominant basis based on which reservation has been given. Caste and their social backwardness and the educational backwardness, which is associated to the historical exploitation of people belonging to certain caste. That was the basis of reservation. So for all the people, say for example, for OBC, for the scheduled caste, for the scheduled tribe, for all the people, the predominant category was the social and educational backwardness, which the Supreme Court has also given the stamp of approval, that yes, they can do it. The only thing the Supreme Court said in the Indira Sahni cases, while giving reservation to the other backward caste, the creamy layer should be excluded. But for all other people, it is based on the principle of the social and educational backwardness. There's no doubt. But what has been introduced by the 103rd Constitutional Amendment Act? What was the criteria based on which the reservation is to be given? Economic weakness. So now the basic question, apart from the basic structure that you have raised, that is definitely true. But the other predominant question that was raised in front of the judiciary is, can the economic weakness be a sole criteria to give reservation? Because so far, what is the principle that is recognized in the Constitution? Social and educational backwardness, which the Supreme Court has to, by reason, has to say, yes, it can be accepted. Otherwise, this constitutional amendment can be struck down. Now, the Supreme Court categorically said that if you see the tool of positive discrimination or the affirmative action, nowhere it is explicitly said that it has to be only for the socially and educationally backward people. The very idea of any form of affirmative action is to help the people who are, let us assume, who are disadvantaged, who are weaker. But it is nowhere explicitly whatever is given in the constitution. Earlier it is recognizing the social backwardness, but the predominant idea is to help the backward, so help the disadvantaged. So the Supreme Court in this particular case said that disadvantage means it also includes what is called as economic disadvantage, not necessarily what is called as the social disadvantage. And because economic disadvantage could also be a factor, so the reservation could also be extended to the economically weaker sections, and by saying that they have approved this particular policy of economic. So many of us might have differences of opinion with regard to this, because even this entire judgment itself, you see there's a majority judgment and a minority judgment. Do you know how many judges have sat in this particular case? It's a constitutional bench, 5 judges. The yes, 3:2. The minority judgment is 2 judges, the majority judgment is 5 judges. But understand that all the 5 judges have agreed upon that economic criteria can be used as a factor to give the reservation. Because the very idea is the affirmative action or any form of the positive discrimination is just to do away with the disadvantage of any sections of the society, be it based on social disadvantage or be it based on economic disadvantage. And now because of the 103rd Constitutional Amendment Act, 2 articles has been inserted. Does anyone remember these articles? Article 15 clause 6 and Article 16 clause 6. So in both the cases, economic weakness has been identified. So now the constitution allows for it because it is also a disadvantage question, and thereby positive affirmative actions or positive discrimination can also be done purely on economic basis, because they said that even if the affirmative action is purely done on economic basis, it is also a tool of social justice. Ultimately, they are bringing it to the point of where? Social justice. So what is the idea of social justice? What is the entire idea of social justice? The idea of social justice is to empower the socially and educationally backward, the weaker sections, to have equal access and opportunities in the society. So ultimately, although the factor could be economic weakness, ultimately it is leading to what? It is leading these sections of the people to have equal access to employment, equal access to education, which they have been deprived by reserving them. So they said that purely economic criteria can also be the basis. And then coming to the point of 50% rule. What did the Supreme Court say with regard to the 50% rule? So both the majority judgment and the minority judgment accepted on one single factor, that is economic factor can be the sole factor based on which reservation can be given, because it is a tool of what is called as social justice. There's no doubt in that. It's also helping them to have equal access to education, equal access opportunities to employment. So yes, economic factor is a valid ground. But the majority and minority differed in one respect. Can anyone tell me to what extent the majority and the minority differed? Although both agreed on this common ground. No, with regard to this itself. With regard to this itself, I come to the 50% rule. With regard to this, while both agreed on the economic criteria is a valid criteria based on which reservation can be given, very good. While the majority said that while economic criteria, while giving reservation, economic criteria can be the sole criteria, the majority said, but this economic criteria will apply only to the general category people, excluding OBC, scheduled caste and scheduled tribe. While the minority said, while economic criteria can be a criteria, but you should not leave out those people. It should open to all the categories of people if you are giving on the basis of economic criteria. That is the minority view. So there was disagreement as to who is to be included and who is to be excluded. But there was no disagreement among the benches whether the economic criteria can be a sole criteria in providing the reservation. So that's the entire crux of this question is revolving around. Okay, so there's a difference of opinion, but anyways, the majority will prevail. So that is the law of the land right now. Now coming to the question of and for the exclusion of the scheduled caste, scheduled tribe and the other backward class, what did the majority said? The majority said that it cannot be seen as an exclusion because they're already covered under their respective reservation. They already have certain vertical reservation. And hence, this EWS, which is given only to the general category, is a reasonable classification. Do you understand why it is a reasonable classification? See, whenever there is differential treatment, the differential treatment between OBC, scheduled caste and scheduled tribe versus the general category can happen only if there is a reasonable classification. So they said that because they're already getting reservation, this is a reasonable classification. So yes, it is allowed. That's a majority view. And then coming to the point of 50% rule. What did the Supreme Court said with regard to the 50% rule? In fact, if you look into the Indira Sahni case itself, the Indira Gandhi case categorically said that the 50% rule is not inviolable. It is not something, it is not breachable. It can be breached under exceptional circumstances. Even for the OBC, scheduled caste and scheduled tribe. Leave out the EWS reservation, which is for the general category. Say, for example, today in Tamil Nadu, the reservation is up to 69%, and which has not yet been struck down. In Maharashtra, it has been struck down, but not in the case of Tamil Nadu. Why it has not been struck down in the state of Tamil Nadu? All the matter is sub judice. The matter is sub judice. Why it has not been struck down? Based on facts, they provided data in the court that while in the all India level, in the Indira Sahni case, the OBC population was, backward population was 52%. In Tamil Nadu, we have more than 90% of people backward. So how do we have inclusive development? How do we provide opportunities to all the people with 50% reservation? So we'll have to expand the scope of reservation. That's an exceptional case, although the matter is sub judice. So similarly, this Indira Sahni case itself has given some element of flexibility in exceptional circumstances. But in this case, the judges said, while there are exceptional cases even for other backward caste, scheduled caste and scheduled tribe, the Indira Sahni judgment will not apply in this case, because this 10% reservation is not for the other backward caste, scheduled caste or the scheduled tribe. It is for a new category of people. So it cannot be seen as breach of the rule of law or equality before law. So both the things has been negated. And then they also said that it is also not violation of principle of equality, because they are already covered under different category of reservation. It is just a reasonable classification. By saying this, they have upheld the reservation. Okay, so now with this thing, you'll have to answer that particular question. So if you go to that particular question, can reservation be used as an instrument of affirmative action to address the economic weakness? And then it is saying justify your viewpoints with the relevant reasons. So how many of you agree, can reservation be used as an instrument of affirmative action to address economic weakness? Is there anybody who would disagree with this? Okay, so if you disagree with this, then I'm not saying that you should not write against that, but you should have a very strong reason. You should have a very strong reason. Maybe you can make use of the minority judgment, but even the minority judgment has accepted that. If you see the entire judgment has accepted on one point that economic weakness can be used it. But again, I'm saying if you have sound reasons, you can go against that. But whenever you talk of such topic, especially, you have to be really diplomatic. You should not come out an emotional argument. You may like a policy of the government or you may not like a policy of the government, but your argument should not be an emotional argument just because you don't like that policy. Because we come from different social backgrounds, so we come through different experiences. So the policies of the state is trying to accommodate as much as possible all sections of the people, which may be against a particular section in their opinion. So your argument should be a very rational and very diplomatic argument. I'm not saying that you should not go against it, because it has scope for going against that also, the way the question is framed. But it should be a very rational argument backed by sound logics from the constitution. It should not appear just because you don't like it. It's better. I would say it is better. Yeah, you can do that. While you agree with this particular point, the entire thing, but in your conclusion, you can have a dissenting note and say that this should also may be considered. In that way, you can go it. That is not an issue. In that way, you can go to it. Now, EWS criteria, I don't think it is vague, because it is not defined in the constitution, but it has given the power to the respective state, all the state governments and the central government to notify as to what is EWS. So that is a criticism. I would say the 8 lakhs income is seen as a very high income. That is a criticism, but I don't think it is vague. But I can say that to what extent it can be effectively verified, that's an issue, because it talks about the property and all those things, the values of the property. So how do you calculate the value of the property? You have different values for different property. There's a market value, there's a other value. So these are all the ambiguity in that particular case. That is true. That's why the implementation is very difficult. So you see that people, except for the salaried class, nobody income is accounted. Only the salaried class probably will be left out of this. There are people who make business for 1 crore, but they don't even file an ITR. So all these issues are definitely there. Is it different? I'm not sure. I think it is. I think the state governments can go for it, but as far as my knowledge is concerned, it is 8 lakhs. Okay, but although the authority to prescribe is the state, it is that he is true, but I'm not sure factually whether what he's saying is right, but the authority is the state. All right, okay. Now, the second aspect of reservation is with regard to any questions on this EWS reservation. The second aspect of the question on reservation is the reservation in promotions. That is also has been happening for quite some time. So do you know that there is a constitutional backing for reservation in promotion as well? What do you mean by reservation in promotions? Is the reservation in promotion constitutionally valid today? It is, of course, constitutionally valid. The court has already given its stamp and approval when it comes to reservation in promotion. But all that they have put in certain caveats, certain conditions to provide for what is called as a reservation in promotion. But do you know what is the history of this reservation in promotion? Very quickly. There may be a question, I'm not sure, but yes, you should be prepared for it. Okay, tell me which categories of people are eligible to get reservation in promotion? Only the scheduled caste and the scheduled tribe. Okay, so and what is the relevant article? Does anyone know? Article 16 class 4 and article 16 class 4A. In fact, I would say it is article 16 class 4A. Article 16 class 4 is giving reservation to anyone, the socially educationally backward classes, scheduled caste, scheduled tribe, all those people. So for all those people, it is giving the reservation, and it is giving reservation in the initial recruitment. While it is giving reservation in the initial recruitment, whereas Article 16 class 4A is related to reservation in promotions. And that is now available only to the scheduled caste and the scheduled tribe, not to others. But there's a history behind this reservation. In fact, this Article 16 class 4A was not part of the original constitution. It was later brought into the constitution by the 77th Constitutional Amendment Act. If I'm not wrong, 1995. This is how the reservation was brought in. Now, there is a history behind that. What is the history behind that? It was struck down. You have to go to the Indira Sani case. For the first time, the reservation for the backward class was brought in only in 1990. Before that, there was no reservation to the backward class in public employment. So in 1990, based on the recommendation which is given by the Mandal Commission, the government issued an order. And as per that order, they said that 27% reservation shall be given to the other backward caste, 15% to the scheduled caste, 7.5% to the scheduled tribe. But this reservation is not only in the initial recruitment, but also reservation in promotions. Now, first tell me, what is the need to give reservation in promotion? What is the logic behind this? Why at all there is reservation in promotions? Now, if you apply for UPSC examination, in the UPSC examination, in your prelims, there is a reservation. And then in the final list, there is a reservation. In mains also, there are different cutoffs. And in the final list also, there is a different cutoff. But this is a reservation in initial recruitment. But after getting into the initial recruitment, in successive stages of promotion, also reservation is given. And not for everyone, but for the scheduled caste and the scheduled tribe. Let us not get into the merits and demerits of the policy now, but I'm just trying to understand the reason why. It is very good. So otherwise, see, most of the people in the, let us assume the backward class or the scheduled caste or the scheduled tribe, they get into the service because of the lower cutoff. And that is justified on the ground that the people belonging to the other backward caste, scheduled caste or scheduled tribe, they were not equally placed with the general category to compete with them because of the historical exploitation. And if you don't give them this relaxation in the cutoff, then they are not having equal access. Their opportunity itself is curtailed. So that's an idea of social justice. So giving them equal opportunity. But because of the cutoff, they get into the service. That means mostly they will be in the lower ranks. And you take the top 100 today. So how many students may be from the general category in UPSC? Let us take the example of UPSC. You tell me top 100, how many general candidates are there? Around 80 candidates. I could say that based on my experience, around 75 to 80 candidates, 70 to 80 candidates from the general category. And then if you come down, most of the general category students will be there in right now. If there are 700 seats, the general category students may be over by 350 or 400. And after that, you will have only the students from the other backward caste or the scheduled caste or scheduled tribe, assuming that it is 500 to 600 vacancies. That means who is having a better chance of getting promoted? In the IAS, once your UPSC rank will always matter. So up to a certain level, if you're all batchmate in a particular thing, up to a certain level, you'll all get promoted equally. Say, let us assume till the level of joint secretary, if you're IAS, let us assume. Say for the first 18 to 20 years of your career. Then subsequently, the person who has got the better rank is senior to you, even because after that, it is an apex. The number of vacancies are very less. So who is likely to get promoted to the top? The person from the general category. And if that is the case, not even a single person, unless until he comes in the first rank, which is very unlikely. It may happen, but it is very less. So in this way, if you see, the people who may get to the top positions in the government will be very, very less if this reservation is not there for the scheduled caste and scheduled tribe. So the government wanted to give an opportunity for the backward classes also to represent the higher echelons of the government. And that's why they have given reservation in promotions. But if you see this Indira Sahni case, before the Indira Sahni case in 1990, reservation in promotion was given to the backward class also, other backward caste, scheduled tribe, everyone. But that reservation in promotion was struck down by the Indira Sahni case. Indira Sahni case said that there is no enabling provision in the constitution. You have no power to give reservation in promotion. As an affirmative action, you can give reservation in where? The initial recruitment, but not in reservation in promotion. Then the parliament said, okay, if that is your problem, we'll create that enabling provision. We'll amend the constitution. We have the power to amend the constitution. So they amended the constitution. They brought in this article 16 class 4A, explicitly giving the power to the state to give reservation and promotion to the scheduled caste and scheduled tribe, not to the backward caste. They didn't give the backward caste, scheduled caste and scheduled tribe. But then this amendment was challenged in the Nagaraj case. So Nagaraj case upheld the principle of reservation, but it came out with 3 conditions. What are the conditions Nagaraj case brought in? It said that we have no problem in giving reservation in promotion, but before giving reservation in promotion, you should collect quantifiable data. That means whoever is to be promoted by reservation, we wanted to know. That means the state has to make sure who is giving the promotion. The state is giving the promotion. So the state has to make sure that those categories of people from the scheduled caste and scheduled tribe are really backward. So you collect the data for that. How to collect the data, we do not know. You have to make the policy, you collect the data, but only based on a quantifiable data, you will have to give them reservation and promotion. So first thing is quantifiable data. What is the second condition that was given? The second condition that was given is you can give reservation and promotion provided there is inadequacy in representation. What is the basic objective of giving reservation and promotion? Because the category people from the scheduled caste and scheduled tribe, there may be inadequate representation in the different levels of government. So you should have data for that also, inadequacy in representation. If there's inadequacy in representation, then you collect quantifiable data and make sure that whoever is getting reservation promotion is really backward. When I say that you collect the data to make sure that whoever is promoted through reservation in promotions is really backward, that means the Supreme Court is trying to bring in a concept of creamy layer among the scheduled caste and scheduled tribe. But when it comes to reservation in promotion, what do you understand by the concept of creamy layer? In the Indira Sahni case, the concept of creamy layer was applied to the other backward caste, only for the other backward caste in initial recruitment. What is this concept of creamy layer? The concept of creamy layer is that although they might have born in the backward caste, but over a period of time, they have become socially and educationally advanced. They still belong to backward caste, but what is their social status? What is their educational status? They have become advanced. How? Maybe by virtue of their status of their parents, maybe by virtue of the income that they have got, maybe by the virtue of other things. So the creamy layer should be excluded. The benefit should be given only to the non-creamy layer. But this was only to the other backward caste. But in the Nagaraj case, by the Supreme Court telling that while giving reservation and promotion, we wanted only the backward from the scheduled caste and scheduled tribe get the reservation. That means it is trying to bring in the concept of creamy layer to the scheduled caste and scheduled tribe in reservation and promotion. That's one criteria. Now the second criteria is that there should be inadequacy in representation. That's the second criteria. Third criteria is by giving reservation and promotion, the administrative efficiency should not be compromised. We have no issues, but without compromising the administrative efficiency, which is a very vague thing, but which is a requirement under Article 335. So this is the condition that was given in the Nagaraj case. So against this judgment, again an appeal was made in the Supreme Court. And that case, what is that particular case? That is the Jarnail Singh case in 2018. Again, an appeal was made against this order. I hope you all have the handouts. You can just have a look into the handout. In the Jarnail Singh case. The Jarnail Singh case little modified the judgment that was given by the Nagaraj case. So what is the difference or what is the change that has been made by the Jarnail Singh case? In this particular case, the Supreme Court said that the first condition is not required. What is the first condition? Quantifiable data. The Jarnail Singh case reasoned that the Nagaraj case was wrong in saying quantifiable data, because already in the Indira Sahni case, the Supreme Court has said that the scheduled caste and scheduled tribe are undoubtedly backward. They are a homogeneous community. There is no different community in the scheduled caste or scheduled tribe, unlike the backward caste. They are undoubtedly backward. There is no need to provide any quantifiable data. But this is again confusing the judgment. While they said that there is no need to provide quantifiable data, but they said that the state should ensure only the really deserving should get the benefit. That means among the scheduled caste and scheduled tribe, you don't have to provide quantifiable data, but who should be promoted? Only the really deserving. That means again, they are bringing a concept of what is called as the creamy layer and non-creamy layer when it comes to reservation promotion without giving a quantifiable data. And then the other two conditions has to be there, inadequacy. And then the next thing is administrative efficiency should not be compromised. So this is the judgment that is given by the Supreme Court. Now DOPT, I think in the process of formulating the policy guidelines also, how to implement this reservation and promotion. This is what with regard to the reservation and promotion. So the question may come from any of these topics, okay, if at all they ask a question in reservation and promotion. So this is one area where they can ask you question. And then the second area is with regard to gender justice. So 3-4 judgments and examples if you have, you can add those areas also. And either way, the question can come, okay. So just quickly look into the question number 2 in the topic of reservation. Briefly comment on the constitutional developments related to reservation in promotions in public employment. Also highlight the latest decision of the Supreme Court in this regard. It's a very straightforward question. Okay, so that's not a very difficult thing to answer. All right, so with that, and for the gender justice, how many examples we have written? Try to have at least 4 or 5 examples, at least 4 examples. What are the examples you have written? Medical termination of pregnancy, Shabrimala, armed forces, adultery, and you can add one more thing from Uniform Civil Code, Shabanu case, or you can write triple talaq case. So you can add any of those judgments. Vishaka judgment also you can write. It is also related to gender justice, gender equality and gender justice. You can add that also. But anyways, I'll come up to this particular topic again when I take up Article 21. But they can ask you from any dimension. Just have the examples. You will be in a position to write the answers. Okay, come to the next topic. That is, this is in fact one of the most important topic. UPSC many times asking question. That is from the topic of Article 19. And what is the most important thing under Article 19 is the freedom of speech and expression. Okay, so there are certain basic things probably you'll have to remember when you talk of freedom of speech and expression. Now, first thing is, what do you understand by freedom of speech and expression? Don't look into your notes. Just tell me what do you understand by the freedom of speech and expression. See, for such things, if a question comes, you should be in a position to explain it. You should be in a position to define it rather. So then only you cannot keep explaining that, say, for let us assume 7-10 lines. You should just define it very briefly. What do you understand by freedom of speech and expression? How do you define that? Can I say it is your freedom? It is your right to express your ideas, your thoughts, your beliefs, your ideas, thoughts, your beliefs without any inhibitions. You don't have to inhibit anything in whichever way you want. When I say in whichever way you want, it can be in the form of writing, it can be in the form of printing, it can be in the form of picturing, it can be in the form of any other representations. That's basically what is called as this right to freedom of speech and expression. So once you have a simplest idea as to what is this right to freedom of speech and expression, you should also have an idea that the right to freedom of speech and expression is not an absolute right. You are sure that most of the rights are not absolute. So right to freedom of speech and expression is also not an absolute right. Can anyone tell me the reason as to why the rights has not been guaranteed as an absolute right? You should know the logic also. Sometimes maybe you'll have to give the reasoning in your answer. Can you tell me why the rights has not been guaranteed as an absolute right? Can you give me an example? Very good, hate speech. Because once you provide an absolute right, just because you have the right to freedom of speech and expression, you cannot do whatever you want to do. That's very important. You'll have to balance between the right of an individual and the interest of the society. That's a basic idea. So there has to be somewhere a buffer line. On the one hand, yes, we'll provide the individuals the liberty that they want so that they can grow, they can maximize their potential. But at the same time, there is something that he cannot cross that particular line so that it does not affect the collective welfare of the society. We'll have to balance between both the things. And whatever example she has said is a wonderful example, the hate speech. So in the name of right to freedom of speech and expression, can we engage in what is called as hate speech? I'm quite sure that you are all aware of what is hate speech. Can we engage in what is called as hate speech? We can do that, but the state will punish us for that. Okay, so if you say that, yes, I can do it, of course, nobody can prevent you from doing that. But if you do that, maybe we are liable to face the consequences because it is not protected under Article 19. So the idea is, while on the one hand, there is right to freedom of speech and expression, this right is not an absolute right. And it can be restricted on number of grounds. And in fact, you know that under Article 19, there are 8 grounds on which they can be restricted. Even if you don't remember, at least remember 2 or 3 things. Can you give me some of the examples on grounds on which they can be restricted? Public order, contempt of the court, unity and integrity, sovereignty. So these are all some of the grounds on which they can be restricted. And these are all the major grounds, but under these grounds, a lot of laws has been made. So for example, we have laws of hate speech. Although there is no specific law, there are a lot of provisions in our country which is related to hate speech. Sedition is there, but again, I'll come to this particular topic of sedition, which has been now replaced in the new law. And then we have the Contempt of Court Act. So in this way, there are a lot of restrictions on the right to freedom of speech and expression. Information Technology Act, very good, one major law. So now why I'm discussing this is there can be a very conventional question that can come from this particular topic. Though right to freedom of speech and expression is guaranteed under the Constitution, it is not an absolute right. Comment. So here the answer that you have to write is, you will have to on the one hand explain what is right to freedom of speech and expression. And then most importantly, you'll have to explain as to why on the one hand the right is guaranteed, but on the other hand, it is coming with restrictions. So you'll have to give examples for that also. One example would be, say, for example, hate speech. What are the other examples that you can give? Sedition. Sedition is not to be used right now because sedition has been replaced with a new kind of provision, which I'll subsequently discuss. Any other example? Very good. Criminal defamation. Criminal defamation is an example. Contempt of the court is an example. These laws may be used there. And how these laws are trying to balance between individual rights and the collective welfare of the society. So you'll have to explain those things as well as a part of your answer. if such a question comes. This is a very conventional question in case if they ask. But especially under Article 19, UPSC can also ask questions related to current affairs also, related to a specific topic also. So the first topic that I wanted to discuss is the hate speech. Hate speech. Just come to that particular question that is given after the hate speech. Please come to that particular question. Read that particular question. Then I'll discuss about the hate speech. So this is the latest data that has been released by the National Crime Records Bureau. As per the NCRB report 2022, there is 45% increase in the cases of hate speech. What are the reasons do you think for such increase in the incidents of hate speech in India? Also suggest suitable measures to tackle them. It's a very direct question. It's not a very difficult question. But why I have selected such a question is, unfortunately, if such a question comes, students start writing whatever they know about the hate speech. You should not go and write whatever you know about the hate speech. You should write only what is relevant in the question. So what are the points? Can someone tell me what are the topics at least relevant in this particular question? What has to be part of your answer? No, just the major structure. I'm not asking the answer exactly. What should be the major parts? What are the different parts of this question? Okay, definition of hate speech. Definition of hate speech. What are the reasons for increase in hate speech? And then measures. And then as a part of the measure, you can conclude that answer also. These are the only thing. You don't have to write much. So when you define hate speech, probably you can use some provisions related to hate speech. And when you come for the reasons, you write the reasons, and the measures you can use some recommendations probably given by Law Commission or the other recommendations you have got as a part of that, and then you can conclude it. But here I am very much sure that everybody will be of the opinion that there should not be hate speech, should be regulated. Hate should not be allowed. I think at least there would not be any differing opinion on that. Maybe on the ways and means there can be differing opinion. So now the first thing is, we'll have to understand what is hate speech, and can you tell me which provision of the constitution or which law in our country defines hate speech? Where is it defined? Which one? Just think about it, you can get it. IPC, ITA, Representation of People Act. How many of you think IPC? Please raise your hand. Be confident. IPC. Okay, Representation of People Act. Okay. What is the other act that I said? Information Technology Act. See, today the biggest problem with the hate speech is nowhere defined. We do not have a definition of what is hate speech. We do not have a legal definition of what is hate speech in our country. So you should be aware of that when you answer a question on what is called as hate speech, because that is also one of the reasons why we are not able to control what is called as hate speech. We do not have a legal definition. All that we have is different provision in different laws which is related to hate speech. But we are not yet defined hate speech. All that we have is, one is a definition that is given by the Law Commission of India, and other is a definition that is given by the Supreme Court, but nowhere legally it is defined. Okay. So you can have a look into the definition which is given by Law Commission. You can use any of these definition, very simple definition. Is it defined in the? No, it's nowhere defined. Hate speech. The new law has changed some of the provisions of sedition and other changes, but hate speech is not covered. Okay, so if you look into the definition of hate speech, what is this definition is saying? That any form of speech which is trying to incite hatred against the people or sections of people based on the basis of religion, caste, sex, or sexual orientation, whatever be the thing. So if there is any form of violence that is, or hatred that is promoted based on all these categories, then that can be considered to be what is called as a hate speech. But we do not have a proper definition of hate speech. But today the Supreme Court of India has recognized that hate speech has come very important problem in our society. Do you agree with this view that hate speech is really an important problem today? It has the potential to divide the entire society. So it has to be, I would say that it has to be taken very seriously and it has to be immediately addressed by the law enforcement agency. A similar view has also been taken by the judiciary. Number of incidences of hate speech are really threatening in our country, where the religious leaders have openly called for termination of the minorities, which is very worrisome, which has happened in some of the religious meetings happened in Uttarakhand, I think Himachal Pradesh, in Delhi. In certain areas it has happened, which the Supreme Court has taken strong cognizance of these things. So, but then today the biggest problem is we do not have a specific definition of hate speech. We only have different provisions of different law. Some of the provisions include IPC, some of the sections of Representation of People Act. These are all not defining hate speech, but there are provisions which is related to hate speech where it makes it a punishable offense. Some example that I have given, if you look into, what are the provisions that I mentioned there? One is section 150, 153A. So this section 153A is related to promoting disharmony between different sections of society. So it is dealing with any speech that promotes disharmony between different sections of society. That's a punishable offense. What is the next section? Section 295A is related to hurting the religious sentiments of the people. Hurting the religious sentiments, then that is a punishable offense. The first thing is promoting communal disharmony. The second thing is hurting the religious sentiments of the group of people. So that is a punishable offense. So what is the third thing? 505. So section 505 of IPC is again related to misinformation, fake information, spreading of mis and fake information. So that is covered under section 505. What is the next section? Section 123 class 3, which you may be aware of, where any political candidate or their agents, if they try to polarize people on the grounds of religion, race, caste, sex, then that is considered to be a electoral offense. That's an electoral offense. So we do not have any provision right now which is directly related to what is called as hate speech, but yes, we have different provisions under the different laws which do indirectly relate to the idea of what is called as hate speech. But the biggest problem is none of these things specifically and exactly define what is hate speech. And once you do not have a proper definition, what is the problem? What kind of problem do you foresee if something is not specifically defined? Vague, it becomes vague. When it becomes vague, two things are possible. One, it can be arbitrarily used. Second, conviction becomes extremely difficult. How do you convict? The conviction rate is going to be lesser because they'll always find loopholes because the law is not defined properly. That is one of the reasons as to why it has not been done. But I have we'll come to the reasons, but we'll try to understand what are the causes that what are the reasons as to why the hate speech is in the increase in our country. So see the causes there. One is polarization of the society for political reasons. So do you agree that the polarization is happening? I'm not saying everyone, but we cannot rule out the fact that the polarization is not happening. Okay, so people are being polarized on religious grounds, which is very unfortunate. And some of the critics also say that today this is also happening because it's a way for the politicians to be in the limelight. What does it mean when I say it is a way for the politicians to be in the limelight? For them to come in to hit the newspaper headlines. When they speak like this, the media is giving attention to them. But otherwise, if they talk about the Indian constitution is very good, it has these features, nobody is caring about it. Probably the media is giving attention when they talk about these things. So for example, you have seen politicians in during the elections who have been issuing some kind of hate speech has been given a lot of attention. So that is also what the critics say. And then the third thing is lack of legal definition for hate speech adds to its ambiguity. When I say this also has a reason because there is no legal definition, then they also realize that the conviction is not easy. And there is a lot of opportunities they can speak, still they can escape from the punishment. Okay. So there's no lack of legal definition. Lack of executive enforcement. Even there is some element of problem from the enforcement agencies also. That also we have to accept. And then lack of judicial activism in the domain of hate speech. What does this mean? Do you agree that there is lack of judicial activism? So what do you understand by this judicial activism? Which anyways, I'll discuss when I take up the judiciary elaborately, but have a basic idea. What do you mean by this judicial activism? And how is judicial activism different from judicial overreach or judicial adventurism? Okay. Hmm. Judiciary. Very good. Activism is to fill the gap. Good, good. I got the essence of what you're trying to say. See, try to understand what is judicial activism. So, judicial activism is a proactive step that is taken by the judiciary. But what forces the judiciary to do that is that there is a vacuum, or there is absence of law, or there is absence of guidelines. And as a result of which, the rights of the people are getting affected, or there is a grave violation of the constitutional principles, which is the function of the other two organs, which is a function of the legislature to bring in a law, which is a function of the executives to bring in a policy. But if they fail to perform their job, and because of which there is a serious concern, then judiciary is forced to fill that particular thing, especially to protect the rights of the people. So that is basically seen as judicial activism. It has a very positive connotation. But whereas on the other hand, what is judicial overreach? Judicial overreach is an explicit intervention in the domain of other things. You are not focused on protecting the rights, or there is no gap per se, but still you are trying to make laws which you are not supposed to do under the constitution, where you breach the doctrine of separation of powers. So such type of actions are what is called as judicial overreach or judicial adventurism. But here what we are talking about is the judiciary can be judicially active. It can be more proactive in terms of addressing the issues. It can issue guidelines, or it can give certain definitions if they want. So that is what we are expecting. So lack of judicial activism. And then the next thing is lack of political will. What do you mean by lack of political will? Even the politicians does not want to bring in a very strict law, very definite law. What prevents them from doing this? If they have a political will, they can bring in a law. It's just an ordinary law. If they're making constitutional amendments, what prevents the government from bringing a law where they can define what is a hate speech, and to give direction to the executives to punish those who are engaging in what is called as hate speech? So yes, overall there can be a lack of political will. Already the law commission has given certain recommendations to do certain things which they have not followed. So these are all examples that you can say. But what could be the consequences of hate speech? There could not be any positive consequences. There's only negative consequences when it comes to hate speech. What could be the consequences? One is marginalization and prejudice. What do you mean by marginalization? Marginalization means a particular section of people are cut off from the mainstream development. They're cut off from all the, I would say, access to opportunities, privileges. You marginalize them, and completely they'll be cut off from all the benefits. So when you marginalize, then it automatically get a feeling of what is called as prejudice. What do you mean by prejudice? Prejudice means having certain stereotypes or negative attitudes. That is basically what is prejudice. So the moment you marginalize a certain sections of the people, so automatically they are having to have prejudice against the majority. So when there is a prejudice, when there is a marginalization, what is the natural outcome? The natural outcome is conflict. Conflict is inevitable. Violence, hatred. So these are likely to happen. So that is very dangerous for a multi-religious and multicultural country like India. And overall, it is also threat to various constitutional values like the fraternity, the ideas of secularism. It is going to ultimately affect that only if it goes unchecked. So what could be the way forward? So way forward is just an example that I given. You can also think, what is the way forward? One is, do we have to bring in reforms? Do we have to define? We have to bring in an explicit law. So you can recommend all those things. The Law Commission of India has recommended to bring in at least 2 amendments to IPC. There are 2 sections that I have given. What are those 2 sections? 153C and 505A. So which is trying to define and punish hatred, because there's no specific law for hatred. If some speech is putting hatred, it is only talking about communal disharmony and all those things. But they wanted to have certain laws which is specifically talking about hatred, spreading hatred towards sections of society. And then there is another section also. So this has already been recommended by the Law Commission of India, which has not been implemented. the Parliamentary Standing Committee, which means the DRSCs. So they have gone one more step and they said that not only we have to amend the Indian Penal Code, today we have to amend the Information Technology Act as well. What is this Information Technology Act is related to? Information Technology Act is related to regulating the content in the online, the digital media, and the other spaces. So today, a lot of hate speech is spread through the digital mediums. So it also requires an amendment to the Information and Technology Act to deal with the issue of hate speech. Okay, so that is the recommendation they have given. And in addition to that, if you have any recommendations, you can share it. What could be the other recommendations? What could be the other way forward with regard to hate speech? Hate speech means only this much. You should have a definition of hate speech. You should know that it is not defined. You should know some of the provisions of hate speech. You should know what are the causes for hate speech. What are the consequences of hate speech? What should be the way forward? If you have this much, maybe you can, if you want, you can have one or two incidents of current examples, if you can add. So depending upon the question, you write an answer. So that would be sufficient enough. All right. What is the next question? Come to the next topic. Sedition versus provision of S. Who is having the ultimate authority? Now it is for the courts to interpret. See that the police can file the cases. The police has no authority to punish anyone. The police is a law enforcement authority. They can just arrest and they can prosecute in the court. So ultimately, who is to be convinced? The court is to be convinced. But that depends upon the evidences that is produced by the police. So because they are a law enforcement agency, they have to produce evidences. So in the absence of proper definition, it may be manipulated. That is one of the biggest problems. So if you ask me who can punish, it is the court. But arbitrarily, because of the definition is not very clear, arbitrarily cases can be filed by the police. And the police can harass someone, the police can leave someone. So this arbitrary is there. So unless until you define it properly. ECI has no role in defining hate speech. ECI has no role, let us assume, in bringing a law. ECI cannot do anything. But ECI has a predominant role to prevent hate speech during election rallies when the model code of conduct is in place. Because the entire country is under the control of Election Commission of India when the country is going for elections. Of course, when I talk of the general elections, the entire country is under the control of the Election Commission of India, and the ECI can make use of the Model Code of Conduct. The ECI can make use of the Representation of People Act. The ECI can make use of the Indian Penal Code. The ECI has got all the powers if they wanted to prevent the hate speech. So all these things are there. So there is no doubt in that. Okay. But only when the elections are happening. Okay. So please come to the next topic. Sedition versus the provisions of the Bharat Nyaya Sanhita Act. So this topic I have picked because there's a lot of articles which is talking about now the sedition has been repealed. In the sense that no longer the sedition is there, it has been replaced by certain other provisions in the Bharatiya Nyaya Sanhita Act 2023. What is the status of this Bharatiya Nyaya Sanhita Act? See, the class will be really useful to you only when you have the basic knowledge, because you are all appearing for the mains examination. So I expect that you have certain level of understanding. Okay. So what is this Bharatiya Nyaya Sanhita Act? What is the status of this act right now? Has it come into force? No? Sure? It has not yet come into force. Although it has been published in the Gazette, assented by the President, it has not come into force. When it is likely to come into force? As per the newspaper reports, it is 1st July. But we are not sure because today the government is not a very strong government. Already some of the parties are opposing it. But as per the newspaper reports, it is 1st July 2023. But whether it comes into force or not, that is not our concern as of now. But for us, we should know what is the provisions of that for the purpose of the examination. So do you know what kind of changes has been made in this law with regard to sedition? And before I get into that, who can tell me what is a sedition? Because sedition was also considered to be a very controversial topic earlier, but there is some kind of change in this particular act. So can anyone tell me what you understand by the concept of sedition? What do you mean by sedition? So any form of communication which is likely to promote hatred, or which is likely to promote contempt, or which is likely to incite violence against a state. So all these things can be seen as a sedition, which was a punishable offense earlier under which section? Section 124A. So that's a definition for sedition. And do you know what is the punishment that can be given for sedition? It can be 3 to 14 years, minimum 3 years to maximum 14 years of imprisonment. It is seen as a very serious offense, which was brought in by the Britishers, especially to protect and prevent the freedom fighters from being critical of the government. So that is the idea of sedition. And then subsequently, there was a lot of criticism to this sedition. Over a period of time, number of people were arrested under this sedition, and it was subject to a lot of criticism in our country. Can anyone tell me what are the criticism to sedition? The first and foremost thing, it has a chilling effect on right to freedom of speech and expression. That means it is curtailing the right to freedom of speech and expression, because in most of the cases, sedition charge was invoked against those who have been very critical, who have been very vocal in their criticism against the government, their policies, and all those things. So they're not very happy about this particular thing. So first is it has a chilling effect on free speech. And it was subject to a lot of misuse. And in most of the countries, they are not using it. Even in UK, they do not have such a provision. So these are all some of the points which they have argued. But what was the legal status of sedition? Before the Bharata Nyaya Sanhita Act, what was the legal status of sedition? Can anyone tell me? Yes, the Supreme Court, I think in 2022 or something, has put a temporary stay upon the execution of the sedition. But before that, it was legally valid. In number of cases, it has been challenged. But in most of the cases, the Supreme Court upheld the validity. But one notable case is the Kedarnath case. Does anyone know what is this Kedarnath case? I think in 1962. It was one of the influential cases where the sedition was challenged. Did you know what the Supreme Court said in this case? The Supreme Court upheld the validity of sedition, because the Supreme Court said that the state has to balance the interest of the individuals and balance the interest of the national security, because there are a lot of issues related to the national security and all those things. So people, if they create any violence, it can have an impact on the security of the state, and hence we need to have the sedition charge. But at the same time, what they have done is they try to misuse the sedition law. And they specifically said one precondition. What is that condition? When the sedition charge can be invoked. One of the biggest problem, when I talk of the criticism, one of the biggest problem with regard to sedition is also the vagueness of the law. The law being very vague, because nothing has been defined. What is hatred? What is contempt? So nothing has been defined. So many times it has been invoked. So the Supreme Court said that in order to prevent, while we uphold the constitutional validity of sedition, but if any speech, if it incites violence, or if it is likely to incite violence, only under that condition, you can invoke what is called as sedition. If somebody is speaking something and there is no violence against the state, then you should not invoke violence. Sorry, you should not invoke what is called as sedition. I can give you some examples. Say, for example, based on this particular judgment, there were a case against a few individuals who shouted Khalistan Zindabad. 4 individuals in the outskirts of Delhi, they have shouted what is called as Khalistan Zindabad. And then subsequently, the state has invoked the sedition charges against them. Do you know what happened to this particular case? Because this case, whatever I'm telling, happened after the Kedarnath case. It happened, I think the name of the case is Balwant Singh case, which happened in 1980s or 1990s, after the Kedarnath case. And the state invoked sedition charges against these youths from the Sikh community for shouting Khalistan Zindabad, and then the matter has gone to the court. So what do you think that the court has said? Was the sedition charge right or wrong? What was held by the Supreme Court? The Supreme Court said wrong. So definitely we are not saying that it is the right thing to call what is Khalistan Zindabad, but the offense that you have invoked is not the appropriate thing, because it has not resulted in what? violence against the state. There is no incitement of violence. 4 people are shouting, nobody reacted to that. So there's no incitement of violence. So the Supreme Court said that the condition that should be contingent upon before invoking the sedition is that there should be incitement of violence, or there should be at least an intention to incite violence. If any of these things are not there, then you cannot invoke what is called as sedition charge. So this is somehow they balance. On the one hand, they said it is constitutionally valid, but at the other hand, they try to prevent it misuse. So this is the understanding you should have. Now you come to the Bharatiya Nyaya Sanhita Act, and subsequently this continued for a long time. And in 2022, the Supreme Court put a stay on the filing new cases on sedition, because a lot of PL has been filed in the Supreme Court. The Supreme Court said, okay, till the time we decide on this matter, no new case has to be filed. Even the all the pending cases should be put on stay. But in the meantime, before the judgment, the government is now coming into the new bill, which has now become an act. So does the new act change the sedition? Has it changed the sedition law? It has changed the nomenclature. Please come to the question. Please read the question. So what is the question? Do you think that the criticism to the sedition law has been taken care in the new Bharatiya Nyaya Sanhita Act? So first of all, you should know what is sedition to answer this question. You should know what was existing criticism to the sedition law. Now the question is asking, do you think that the criticism to the sedition has been taken care in the new Bharatiya Nyaya Sanhita Act, which replaces the colonial era Indian Penal Code? That's the question. So that means to answer this particular question and critically analyze. What does this critically analyze means? You can be critical. You can come out with both positives and negatives, and finally you can come out with your own suggestions or opinions, the way that you conclude. So to answer this particular question, you should know what is sedition law as it is there in section 124A. What are the criticism of that? And then presently, what is a provision in this present law? Is the present law taking care of the previous criticism? And even if it is taking care of the previous criticism, is there any new criticism in this law? So all those things has to be part of your answer, and then you finally conclude. So only when you write all these things, your answers will be complete. Okay, so that is what the question is asking for. Okay, so who can tell me what is there in this new law? Is there anybody aware of what the new law is saying with regard to sedition? In fact, the word sedition itself is not there, because they have taken away these words of what is called as hatred, contempt, incitement, and they made the law specific to what is called as any action of an individual which is affecting the sovereignty, unity, and integrity of India, rather than using the word what is called as hatred, contempt, or what is called as disaffection. So that is not there. Instead of that, what has they have put? The actions which is against the sovereignty, unity, and integrity of India. And specific targets has been put. So what can be seen as affecting the sovereignty, unity, and integrity of India, although it is not defined, they have tried to give us some understanding of what can be seen. So any action which is related to secessionism or which is related to separatism, they are all considered to be a punishable offense today. So what this means by secessionism or separatism? What is this idea of secessionism or separatism? Anybody promoting the idea of disintegrating a part of country outside India. Say, for example, somebody calling Jammu and Kashmir is not an integral part of India. They are spreading an idea of related to secessionism or separatism. Now, those things can be seen as a punishable offense. Okay, now if you see, one good aspect of this is that the law has been very specifically related to that, instead of using a very vague word like hatred, contempt. And what is the biggest problem with the words like hatred, contempt, or incitement of violence is that it was very vague, and even milder criticism against the government has invoked the sedition charges. And you will also know that one of the biggest criticism of the sedition is, as per the National Crime Records Bureau data 2022, I think the conviction rate is less than 3%. What is the conviction rate? less than 3%. That means if 100 cases are filed, less than 3% actually get convicted in a court of law. That means it has been widely misused. It's very clear. And one of the reasons for that is the definition was so vague. So today that has been replaced, and instead of that they have taken what? Anything, actions that would affect the unity and integrity of India, and if they engage in acts like what is called as secessionism or separatism. So to some extent the vagueness in the definition has been taken care. So that you can say yes, now the definition is not vague, and it is not merely for hatred, something which can be misused, but it's a very big problem. So definitely you agree, you all agree to the point that anybody who is doing something which is against the unity and integrity of India, can the state be a mute spectator to that, or the state should punish them? The state has to definitely punish them. So to that extent it is all clear. But there is again a big problem, and apart from that, if you see the addition in this particular law, the definition has provided for a wider procedural things. So the definition is include offences which can be done under offences that can be done using electronic communication as well. So these things are not specifically mentioned there. It can be an electronic communication also, or use of financial means, not necessarily physical actions, use of financial means. Somebody is giving some money, not necessarily he is in the ground and he is doing something against the unity and integrity. He is just providing the money and he is instigating these things. That is also covered. So the definition is very wide, and he tried to reduce the ambiguity. All these things are good. But what could be the possible criticism? And accordingly, because it is related to unity and integrity of India, they have also expanded the punishment also. The punishment minimum 3 years has been now increased to 7 years. It is 7 years up to 14 years. They have increased the punishment also. And earlier, if you see the punishment, it could be 3 years or 14 years. It could be imprisonment or fine or both. But under the present law, there is no provision for fine. There is only imprisonment. And the imprisonment also have been increased. But ultimately, the good thing is they try to take away the vagueness in this particular law. But what could be the criticism even in this particular act, which has not been taken care? First and foremost thing is the law is more stringent. That could be one criticism. The second thing is this law has given even wider discretion. It is still more discretion because of the fact what amounts to disturbing the unity and integrity and the sovereignty has not been defined. Although they have given some direction, it is even giving broader scope tomorrow to the law enforcement agency. And in the previous law, if you see, as per the Supreme Court judgment, what is a precondition to invoke the sedition charges? Incitement to violence. At least there is some element of protection to the individual, that only when they incite and violence, then there can be sedition charges. That precondition is not here. That means it is even giving a lot of discretion on the ground that if somebody is affecting the unity and integrity, he may not incite violence, but even if his action is related to affecting the sovereignty and integrity of India, he can be punished. So the critics say that we'll have to see the implementation of this particular act. It appears that the definition has been made better, wider in compared to the previous version, but still even here there is vagueness. Here there is even scope for more punishment. Here it is also possible that there is not even a precondition for violence which existed earlier. So we'll have to actually see the implementation of this particular act. So this question also gives you the scope for constructively criticize as well. Okay, so and then you can conclude your answer. Okay, so I just wanted to take only one last topic, very easy topic before we complete this. So write down the next, come to the next topic, that is digital media regulation versus the fundamental right to free speech. Normally, what is the timing of your class? 8:30 or 9? I was informed it is still 5 to, oh, sorry, it is still 8, no? It is 5 to 8. What is the time right now? It is 7:30. So 5 to 8, another 15 minutes, I'll complete the topic, okay? So the next topic is digital media regulation versus the fundamental right to free speech. So this topic was also there in the newspaper for a number of reasons. Can anyone tell me why this was there recently? There was a particular regulation that was brought in by the government. Now it is stayed by the Supreme Court. See, there is an Information Technology Act, which is basically to regulate the content in the digital media, which will regulate the social media platforms, which will regulate the streaming services like the YouTube, the content in the YouTube, which will also regulate the news publishers. Today, a lot of digital publishers are there. So to regulate all these contents, we have got a law, which is the Information Technology Act. It has other provisions also, but one aspect is they have to deal with all those things. Under the Information Technology Act, the government can also make rules. The government can also make rules in order to ensure that on the one hand, there is free speech, but on the other hand, this is regulated. This is also regulated. So again, this topic is very much related to the right to freedom of speech and expression. Now, recently, the government came out with a rule under the Digital Information Technology Act, where they provided and they came out with the concept of what is called as fact check unit. How many of you are aware of this particular news? Fact check unit. The government can appoint a fact check unit. And this fact check unit has been recently, this particular rule has been recently put to stay by the Supreme Court. Do you know what is this fact check unit under the information technology rules? Anyone? What is its fact? See, the overall objective of the Information Technology Act is to identify the fake news, misinformation, because the fake news, misinformation has a lot of potential to create hatred and violence in the society. So the idea is, on the one hand, the citizens have certain medium for free speech, where they can use the social media platform, and expressing your ideas and viewpoints as a part of digital media or social media is also part of your right to freedom of speech and expression. But that right is not an absolute right. What if somebody is promoting fake news or misinformation or hate speech? Will it have a divisive impact upon the society? So definitely the state can regulate these things. And to regulate, the state have made a lot of rules under this. Information Technology Rules 2021, 2022, 2023. Now the 2023 rules came out to the concept of what is called as fact check unit. So what is this fact check unit? Very good. So if you look into this, see, you and me have how many of you have an account in Facebook? Most likely, maybe not active now, but you do still have an account. You have an account in WhatsApp. You have an account in other social media platform like Twitter and all those things. So we are all the users. And someone who owns that, they are intermediaries. So Facebook is an intermediary. It's an intermediary in the sense that we are the originator of information. We can give some information. They act as an intermediate and they take this information to others. They're just a platform. Now, the fact check unit, which was brought in by the government, will be a government appointed statutory body. It will have certain members. So they will monitor the contents in this social media intermediaries. What is the content that is circulated, especially those social media intermediaries which have subscribers more than 50 lakh users. So the fact check unit of the government will see the content in Facebook, it will see the content in WhatsApp, it will see the content in maybe Instagram, Twitter, whatever be it, provided that they have more than 50 lakh users. And if there's any misinformation, false information, fake news, hate speech, then the fact check unit will raise a flag and tell the social media intermediary to remove this content and to delete this content. So the fact check unit is to verify all these things. If something is against the interest of the state, something is not very good, so they'll raise this issue with the social media platform and they have to remove this information. If they fail to remove the information, then they will lose what is called a safe harbor. So there is a provision under the Information Technology Act, Section 79 of the Information Technology Act, which provides for what is called as the safe harbor. What is a safe harbor? Anyone know? Safe harbor is a provision which is a legal protection which is given to the social media intermediaries. See, suppose if I own a Facebook account and I put something which is a hate speech, and the social media intermediary, Facebook, cannot be liable for this. Who has to face the consequences? I'll have to face the consequences, or whoever is the originator of the information has to face the consequences. Provided that if the fact check unit is telling the Facebook to remove this content, and if the Facebook is ensuring compliance, then there is no liability upon Facebook. But if the Facebook or the social media intermediary, the example that I've taken is Facebook, if they're not following these compliance, then the liability will also be on the Facebook. So that is what this fact check unit is telling. So normally they have a safe harbor protection as long as they ensure compliance with the direction which is given by the fact check unit. Now, this fact check unit, the biggest problem is when the government is directing something. When the government is directing something, the social media intermediary has to remove it. Media has to remove it. I think there are certain time limit within which they have to remove it. Now you tell me, as a part of your general sense, you apply that, what would be the right process? When the fact check unit is bringing this to the notice of the social media intermediary, should the end user should also be aware of this, or he should not be informed? There is an end user, it can be X, Y, Z, anybody. So should the end user be informed, and he should be given an opportunity to explain why this content, what is his opinion about this content, or just the government will give the instructions and immediately it has to be removed? End user should also be removed. If you do the due process or the proper procedure, the end user should be informed. But now the government has authority to directly tell, and immediately they have to remove it, even without taking him or giving him the notice. So the lot of social media intermediaries and various activists have brought this to the notice of the Supreme Court. It seems to be over regulation. It is not about regulation, it is over regulation, which may have an impact on the right to freedom of speech and expression. We agree that the freedom of speech and expression can be regulated, but there should not be over regulation. And if there's over regulation, then there can be a lot of over censorship on what can be done in the published and what can be spread in the social media platform. So this matter has gone to the Bombay High Court. The Bombay High Court is looking into this particular matter, but they have not given a judgment yet. In the meantime, the matter is, because in the Bombay High Court, they asked for a stay. The Bombay High Court did not give for a stay, but the matter is still sub judice. In the meantime, the matter has gone to the Supreme Court. The Supreme Court has already imposed a stay on this fact check unit till the time the matter is decided. So to that extent, they may not ask a question on fact check unit, but they may ask you a question with regard to the Information Technology Act or the Information Technology rules, which provide to regulate the right to freedom of speech and expression, but does it amount to over regulation or not? So please come to the question, the first question. Can anyone read the question? There's a small mistake in the first question, make a correction. There is a need to maintain delicate balance, DELICATE, delicate. What do you mean by delicate? Fine balance. You'll have to maintain a fine balance. There is a need to maintain delicate balance between regulation and the exercise of fundamental right to free speech. Examine the statement in the context of criticism surrounding India's Information Technology Intermediary Guidelines and Digital Media Ethics Code. What is this question? Can anyone decode this particular question? Very good. Regulation versus right. There is a need to maintain delicate balance between regulation and the exercise of fundamental right to free speech. Examine the statement in the context of criticism surrounding the Information Technology Act. So this question helps you. This question will assess whether you are giving all these things. First of all, you should have the understanding of the relation between rights versus the restrictions that can be imposed. And then the second thing is, you should also be probably aware of some of the restrictions. You should also be aware of some of the restrictions in the form of the intermediary guidelines. If not all the rules, you should be aware of some of the important things like the fact check unit and other things. I have given a lot of rules. So probably you may have to put one or two things. And then in the light of these things, you should also analyze whether it will amount to over regulation or not. You can be critical of these things also. To what extent, if these rules are there, how it will impact. Okay. So just quickly look into your notes. The rules you can see it there, except for the fact check unit, others are self-explanatory. So what are the criticism of these rules? Come to the criticism of the rules. Ambiguous language. Most of these rules are ambiguous in nature. So can ambiguous rules lead to over censorship? Definitely it can lead to excess censorship. And if there is excess censorship, it will suppress the legitimate dissent and political criticism. Can the government misuse it? Especially the political criticism can be suppressed, it may be removed. So to suppose if the fact check unit has not been stayed, during this election, I have seen that there are a lot of YouTubers who have been very critical of various political parties. And the government could unilaterally put and close all these accounts by using this fact check unit, which has been stayed by the court anyways. So undermine open dialogue, essential for vibrant democracy. It can hinder artistic creativity and expression. See, if the rules are very rigid, for an artist, he cannot keep into mind what are the very rules. He has to be really innovative in his idea. So it can also have an impact on all these things. And then a smaller digital platform may face financial and logistic challenges. This is, suppose if there are too many rules, these rules and compliance may not be possible for a smaller organizations. The bigger organizations can have the compliance officer. The bigger organizations can have the other rules in place. But this may not be sufficient, or it may not be there for a smaller organization. They will be put in a disadvantage positions. But what are the arguments in favor? You can see. You can see the arguments in favor. The right to free speech is not absolute in character. So the government has a legitimate right to regulate them. So definitely the government can regulate. Especially the government should be in a position to regulate the fake speech, misinformation, and all those things, because the government is supposed to do this because of the fact otherwise it can lead to hatred and it can lead to violence in the society. So this is the thing. So what can be the way forward? If the other things you can write, but one thing that you please take into consideration, how many of you know about the Shreya single case? Have you ever heard of the Shreya single case? Section 66 it was again related to the Shreya single case. While it has struck down Section 66A of the Information Technology Act, it upheld the Section 69A of the Information Technology Act in the same case. Do you know what is Section 69A of the Information Technology Act is related to? Section 69A of the Information Technology Act is related to, again, removing certain content and closing certain accounts if they want, but after following the due process. The Shreya single case said that yes, you have a legitimate interest to regulate certain contents, but you should follow the due process. You should issue notices, you should seek their representation, and following the due process and procedure, then you can do it. So maybe you can make use of those things in the way forward in the closure statement. Okay. So while the government has a legitimate right to regulate, but it should not over-regulate, and at the same time, the regulation should be following the due process, maybe as directed in the Shreya single case. That could be a way of concluding this particular thing. All right, so with that, I'll end the class here. So tomorrow we'll again continue with the, please listen, just a couple of minutes. So tomorrow again, please sit a couple of minutes. So again, tomorrow we'll continue with the fundamental rights. And tomorrow 5 o'clock when you will come, I'll give you 3 to 4 questions from whatever questions it is there. So do not go and waste the time again. You just revise the points and then you try to come and write the answers. So in this way, every class, whatever we discuss, when you come for the next class, we'll give you some questions. You write the answers and we'll have a brief discussion of those answers also in the class. Okay. Any questions? All right. So we'll again meet tomorrow. Okay. Thank you very much.